Good morning. Welcome to Disorder in the Court. We have a lot to talk about today. The Chad Daybell trial is on day 2. It's been underway this morning for just about a half hour. We're going to get underway with that really quickly here. But we're also on verdict watch for the Nicolae Miu trial, which is the Apple River stabbing trial. So we will be on the lookout for that verdict. But there was also a pretty crazy hearing yesterday, follow-up hearing in the Brian Kohberger case. So while we're in between viewing the Chad Daybell trial, we will also be picking up pieces from those two trials as well. So with that, let's see what's going on with day 2 of Chad Daybell. Welcome. Please come on in and hit that thumbs up.
Before we go on the record, the approach. Yes.
I will be able to fast forward a little bit because I started a little bit late, but we'll probably catch up in about a half hour or so.
This morning. Yes, Your Honor. Defendant, two jurors have returned. The court's also confirmed that the jurors each completed their affirmation this morning regarding not looking into the case during the break. And so we appreciate you following that admonishment as well. One other matter
Just me.
to bring up before we got started with additional evidence is the court's live streaming this hearing in this trial. There is I heard there were some complaints that the audio maybe wasn't coming through very well on that. I'd ask the attorneys.
Definitely not.
Right at the mics. Of course, that helps as well with our court reporter making the record. In addition, the live stream comes directly through the court's official channel. That can be somewhat difficult to find if you go to the Idaho Supreme Court website. However, there is a website on Ada County about this trial, and if you just Google the term Ada County Daybell trial, there's an easy link to find those. All right, Detective Hermosillo was sworn in yesterday. I'll remind you, you are still under oath for your testimony today. And to confirm, not being the state's case agent, I just want to confirm that you didn't review any, well, you're the first witness, so we don't need to do that on this particular witness. So, Mr. Wood, if you'd like to just inquire on further direct, you can do that this time. All right, thank you. Good morning, Detective. Second, when we finished off yesterday, we were discussing what you had found or what you had observed at a burial site, and just for purposes of the jury, what site were you at when you found the body you were speaking of yesterday?
We were at the site that we deemed JJ's burial site.
And where, Your Honor, if I could be given State's Exhibit 10A. And if I may publish that? Yes, it's admitted, correct? Yes.
Detective, if you could, just for purposes of clarification, with a pointer, point out the
Johnny's here.
location you were speaking of.
Sparkles is here. Roll call.
It's the burial site on the other side of this pond, just underneath this tree.
Yeah. Now, you call it a pond, when you were out there on June 9th, was there water in it?
No, there wasn't.
And again, just to clarify, when we had left off your testimony yesterday, is it correct that what you observed was what appeared to be a small body wrapped up in a black plastic bag?
That's correct.
Your Honor, I'd ask that the witness be handed State's Exhibits 10B through 10M. Detective, can you review those exhibits and let me know when you got a chance to?
Nah, it's they said something about the sound a few minutes ago. They said they're working on it, but the sound is terrible.
Detective, do you recognize State's Exhibits 10B through 10M?
Yes.
What do they purport to be?
Photographs, there's a photograph of the west side of the defendant Daybell's residence. And photographs of the backyard.
And do you know when these photographs were taken?
On June 9th, 2020.
Were you the photographer?
No,
But you were on the property that day.
that's correct.
And were you able to observe each of the areas that are photographed in these exhibits?
Yes,
You saw them with your own eyes.
yes,
And are these true and accurate representations of what you observed on June 9th, 2020?
yes.
Your Honor, I move for admission of State's Exhibits 10B through 10M.
Any objection? Judge, just to, into the microphone, please, Mr. Pryor.
I'm sorry, Judge. Judge, just one here on 10B if I could. Otherwise, I'm fine with the rest of the exhibits.
Okay, so let's, do that then. So 10C through 10M have been offered or admitted, and Mr. Pryor, you can board there on 10B.
And officer, you're looking at 10B, is that right?
Yes,
For
sir.
now.
Yes.
Of
And
course,
the
Pryor is
vehicle that's
very
parked
hearable.
in 10B, is that the vehicle that was, the position of the vehicle at the time that you testified about Mr. Daybell?
That's not the vehicle that Mr. Daybell was in. That
Okay. Do you know what vehicle that is?
the driveway looks like a Subaru.
Okay, is that the driveway that you're making reference to?
That's correct.
So in other words, somebody else's vehicle is there. We don't know whose vehicle that is,
It's not the one that Mr. Daybell was in.
but you don't know whose vehicle that is.
I don't know whose vehicle that is.
You don't know when the vehicle was put there.
No, sir.
You don't know who the owner of the vehicle is.
That's correct.
I would object, Judge, on foundation.
All right, Mr. Wood.
Thank you, Your Honor. Detective, so you don't know whose vehicle that is, correct?
Correct.
But you were still there that day. Okay. Do you recognize this as Mr. Daybell's residence?
Yes, I do.
And this is a true and accurate representation of Mr. Daybell's residence.
Yes, it is.
Your Honor, I think significant or sufficient foundation has been laid.
All right,
Judge, I just make a record that I'm objecting also on the basis of relevance. It looks like it's a picture of a vehicle in the driveway.
okay. Well, the picture shows many things, including a vehicle. I'll allow the state to have this admitted, and sufficient foundation's been established, so 10B is admitted as well as the others.
Detective, if you will, or, Your Honor, may I publish?
Yes.
Detective, what did you observe in State's Exhibit 10B?
That is the west side of the Daybell residence. When I testified earlier to coming out and standing in the lawn area, that's not the vehicle that Mr. Daybell was in, but it was similarly parked that way back in. And that's the driveway he was sitting in when I was observing him look over his right shoulder toward the pond area.
Detective, do you have the pointer with you? Can you point to where you were standing when you initially observed Mr. Daybell's behavior?
I was standing here in this area.
And then you said that you positioned yourself so that you could see what you thought he was looking at.
That's correct.
Where did you go then?
I stood more towards the driveway area. The vehicle that Mr. Daybell was in was up further this way. It wasn't backed in as far as this vehicle in the photograph.
And just to clarify, is that when you looked back and saw the activity under what became the first burial site?
Well, I was looking forward at that time. I was facing this direction. And I aligned myself with Mr. Daybell, who was up here more, and he was looking towards this area here.
Now, can you see the first burial site from where you're from that location?
Yes, it's the tree I spoke about earlier. This is the tree where JJ was buried underneath. This right here is the pond. You can see just a little bit more taller shrubs around the top of the pond area. But this is the tree that JJ was buried underneath.
So is it fair to say that even from the front or the middle of Mr. Daybell's front yard, you can see that location easily?
That's correct.
Detective, what did you observe in State's Exhibit 10C?
When I testified, I was tasked with sifting through the fire pit. This is what we deemed the fire pit. It had burnt tree limbs. There was various little pieces of trash. It was in the middle of round cinder blocks. So that's what we deemed the fire pit as.
And the way it appears in that image, that's the way you found it that day?
Correct. It was that morning, yes.
And what do you observe in State's Exhibit 10D?
This is just north of the driveway that Mr. Daybell was sitting in, looking in the same direction. So we're standing on the west side looking east. And that is the tree. And then here's the pond area right here.
Jacob, I'm going to put up State's Exhibit 10A again, and if you can point to the approximate location of where this picture was taken from.
So that last photograph was taken from this area right here.
And so it's fair to say from that location, you can easily see burial site number 1.
Judge, I'm going to object at this point. There's been some leading questions. Continues.
I'll sustain that last question, City.
Right. From that perspective, what were you able to observe?
Burial site number 1, JJ's burial site.
Was it difficult for you to observe it from that location?
The actual grave site on the ground, yes, from that location, but where the tree and the pond are, no, it wasn't difficult.
Detective, what did you observe in State's Exhibit 10E?
So when I testified earlier about the difference in.
Yep, and
length
it's not
of
great
grass and shrubs
destination.
in that 6x6 section that was marked off next to the pond, this is what I'm referring to. If you look close, you can see there's smaller grass and dirt protruding right here. This is probably a little bit difficult to see. There's probably a better photograph. But this is longer shrubs through here, and then in here was like the length of sod and some dirt where there was nothing growing.
And when yesterday you testified being called over to burial site 1, is that what it looked like when you got over there?
That's correct.
Can you describe to the jury what you saw in State's Exhibit 10F?
So
Hi,
when I
Stacy.
spoke about ERT removing the topsoil and the top level of shrubs, this is what I was speaking about. And you can start to see the 3 large white rocks I was talking about earlier starting to come through the dirt.
You testified yesterday about a smell. Was this the same time that you began to smell what you described yesterday?
Yes, as soon as they remove this and the topsoil, that's when I instantly can smell the smell of a decomposing body.
Detective, can you tell the jury what you saw in State's Exhibit 10? Or I'm sorry, 10G.
So as the ERT team methodically removed the soil around the white rocks and dug down just a little bit deeper, this is what we saw. You can start to see there was a smaller rock, but the 3 large white rocks started to show through clearly. When I testified that there was thin wood paneling underneath the white rocks, you can start to see the edge of that piece of wood paneling underneath the rocks. We also noticed that there were roots cut that the ERT team didn't cut. They were already pre-cut. Some of the roots are fairly thick, so that was something we observed as well in that burial site.
Detective, can you describe to the jury what you saw in State's Exhibit 10H?
After the ERT team removed the white rocks, this is the 2 pieces of wood paneling that were underneath.
What did you observe in State's Exhibit 10I?
Solo, are you saying that OJ is dead?
I spoke earlier about the distinction in soil. Some of the soil looked wet or moist, some of it looked dry. Excuse me. What you're looking at here is once we remove the wood paneling, this is what was underneath, and you can start to see the distinction through here of the wet soil. And up here is just the dry soil. So the rocks and the paneling were all through here. So that was the other thing that we observed. And as we took the paneling off, the odor began to become a lot stronger.
The C word took him.
So
Okay.
we were at the right spot.
Bye-bye, OJ.
Your Honor, I apologize for any delay. I wonder if we could just have a very brief sidebar regarding the removal. All right.
Protruding through the dirt. This is what we started to see. It appeared to be like tight wrapped black plastic. It wasn't very too far underneath. It's fairly shallow, but that's what we started to see. And I talked about what appeared to be the crown of the human head.
I guess cancer did what the legal system couldn't. Hello, Teresa.
So once that appeared, ERT team leader Steve Daniels used a small, sharp instrument. And I testified that he made a slit through the black plastic. And you can see the black plastic kind of peeled away on the top of the head. And then I testified there was a white piece of plastic underneath. And this is the white piece of plastic here. He made a slit in the white plastic. And when he did that, you can see what appeared to be brown human hair. Some of the hair kind of came out with the sharp instrument. And that's the hair you can see on top of the white plastic. But that's what you're looking at.
Roger, what you observed in States Exhibit 10L.
Once the ERT team continued excavating, they removed all the soil on top of this small body that was wrapped in completely black plastic. I testified that it appeared to take the shape of the small body in black plastic. And this is what we saw here. It's probably a 4x2 grave, and I'm guessing at those measurements. But it started to take the shape of a small body, and then it had different pieces of duct tape throughout the black plastic on top.
What did you observe in States Exhibit 10M?
Once we lifted JJ out of the ground, there was still wet soil underneath where he was laying. And that's body decomposition. The body had begun to break down. So that's what the wet soil is through here. Again, you can see the roots that were cut to be able to put him in this location.
Detective, once that body was recovered, what did you do? To clarify that question, once that body was taken out of the ground, what did you do?
I assisted the coroner and a few other officers in placing JJ in a body bag, black body bag. Coroner locked the body bag for evidence. We then put it in the back of the coroner's vehicle. The coroner and a Fremont County deputy drove the vehicle up to the morgue, and myself and Lieutenant Rockwell followed behind that vehicle. Once we were at the morgue, JJ was placed in the morgue, and then we returned back to the Daybell residence.
Do you recall who the Fremont County coroner was?
Brenda died.
And do you recall what other officers traveled with you to the hospital?
In my vehicle was just Lieutenant Ron Ball. With the coroner, Brenda Dye, I believe it was Detective Kaiman.
And just for clarification, you had said this already, I apologize, but what hospital did you take them to?
Madison Memorial Hospital
And where is that located?
in the city of Rexburg.
Once you finished that task, what was the next step for your investigation?
We returned back to the Daybell residence. As we got there, we were told that they had possibly
Judge, I'm gonna object at this point. There's some hearsay.
I'll ask another question. Without telling the jury what anyone told you, what did you do when you got back to the residence?
we assisted in a second burial site.
And when you got back to the residence, did you observe another burial site being looked at?
I did.
Where was that located?
So through the course of our investigation, we learned that the Daybell family had deemed a section of the backyard as what they referred to as a pet cemetery. And we knew through talking to family members that the pet cemetery had a little black dog statue next to a post that kind of signified where the pet cemetery was. And so when I returned back from dropping JJ off at the morgue, I observed ERT digging in the pet cemetery area.
And did you aid in that excavation?
I did.
What did you personally do?
ERT began taking off top layers of soil in this specific area in the pet cemetery. Once they began to again see wet soil start to protrude through the dry soil, they slowed down and we got on our hands and knees and began excavating that by hand.
And by hand, did you use tools to do that?
We did. They had small tools that we could use, trowels, like paintbrushes, things of that nature.
Approximately what time of day was this?
Say it was afternoon.
And approximately how many people were there with you using hand tools?
There was only a few of us at a time that could work because of the area, but also because of the smell. We had to take turns digging because we were on our hands and knees and the smell was so bad that you could only work for a few minutes before somebody else had to take turns, get on their hands and knees and start digging by hand.
And you said the smell, what did it smell like?
Decomposing body.
How long did you aid in that excavation using the hand tools?
hours. Probably.
And, did you find any?
We did, we ended up, digging down and started to uncover burnt pieces of flesh, charred bone, fatty tissue. Just, and I apologize for the lack of better words, but globs of burnt flesh starting to protrude through the dirt.
And once you found that, how long did you keep working that site that day?
We worked probably until probably 4-ish in the afternoon.
And you mentioned ERT, were they working there alongside you?
There was also other areas being excavated as well, the fire pit still. So everybody was kind of tasked with something different at that point. And once we started getting down a little bit more in Tylee's burial site, we assumed it was Tylee, we could start to see the top of what appeared to be something plastic and green. And at that point, the ERT team leader, Steve Daniels, decided we were done for the evening.
When you were done for the evening, what happened?
We had Fremont County Sheriff's Office, the Madison County Fire Department, bring in 2 large light trucks to illuminate the crime scene. The crime scene was taped off. We had officers from Rexburg City Police, deputies from Fremont County Sheriff's Office that remained on scene all night long, walking the perimeter to make sure that the scene wasn't compromised. And it was well illuminated.
And did you return the next day?
Yes, we did.
And when you returned the next day, who else returned?
Everybody that was there the previous day.
So ERT came back
That's correct, yes.
and other members of the FBI,
Yes,
Fremont County officers,
yes.
Rexburg police officers.
Correct.
And I believe you testified earlier that there were some attorney general investigators there as well.
Yes,
And they were all there that second day.
that's correct.
Approximately what time did you arrive that second day?
We started fairly early. It was approximately 7 in the morning.
And what did you start doing when you got there on the second day?
I went back to Tylee's burial site. We had put up canopies to keep sunlight and wind. There was media, helicopters flying overhead, so we wanted to keep the scene from being compromised as much as we possibly could. And at that point, we got back down on our hands and knees and began digging again with those same little tools to get down to see what exactly we were going to take out of the ground at that point.
And so and then what happened next? Did you continue to do that work?
Like I said, we would take turns digging because the smell was so bad. And we would just keep excavating slowly around this green object that started to come through the dirt the first day. So it started to take a shape, a roundish shape, when we began digging down and methodically removing dirt. And at that point, we could start to see what appeared to be the shape of a green melted bucket that appeared to have the remains of, we assume were Tylee that were charred and burned inside it.
And were you there for the excavation of that bucket?
Yes.
How did that happen?
Once we got down to what we thought was the bottom of the disformed bucket, we observed part of a human skull underneath the bucket. There was some teeth that we ended up excavating from underneath. At that point, the goal was to lift that out of the ground. And so there was we made kind of a little hole around it to try to get underneath. So we put tarps out. Like I said, the goal was to try to lift it completely out without manipulating it in any way. But when we tried to do that, when we lifted it, it all broke apart because there was nothing holding it together. So at that point, we had to go back in and remove all the pieces of the charred flesh and burnt bone and organs and pieces of Tylee that put onto the tarp.
And while you were doing that, you talked about smelling. Is that still present?
Yes, very much so. Strong odor, yes.
Were you able to observe the lack of a better word, total removal of that green bucket and its contents from that excavation site?
We were able to lift everything out at that point. We put it on the blue tarp. There were photographs taken, measurements taken by ERT. Once that was completed, we dug down even further to make sure we didn't miss anything. Once we figured out everything was out of the ground, that tarp and those and Tylee's remains were then put into a body bag. In the corner again, lock the body bag for evidence purposes. And Tylee was also transported to the morgue.
And did you follow along when Tyler was transferred to the morgue like you did with JJ?
We did. We followed in the same manner. Myself and Lieutenant Ball. Once Tylee was placed in the morgue, we returned back to the Daybell residence.
Your Honor, I'm going to be asked that the witness be handed State's Exhibits 11A through 11G.
Yeah, pretty empty looking for as much as we can see. As usual.
Mission of these as exhibits.
All right, exhibits 11A through 11G are admitted without objection. This time, as we get into this evidence, I'm going to announce that because of the graphic nature of some of this evidence, I'm not going to be showing this on the court's live stream, nor to the general public in the courtroom. The jurors will be viewing the evidence as well as the parties are permitted to see that. In addition, the court will provide an opportunity for any victims that wish to see the evidence in a private setting to view it as it's now been admitted into the record. But we made arrangements to not display this to the general public. And so, Mr. Wood, with these exhibits, that's how we'll proceed. And we will not include that on the live stream, but you can discuss it on the record in open public with witness.
Here comes the graphic evidence, but we won't see it, hopefully. Detective is bracing himself.
Detective, can you review that exhibit, those exhibits. And Your Honor, I understand these are already admitted. I am still ask a few foundational questions just to establish knowledge.
Very well.
For the record. Detective, what does states exhibit 11 report to be? And its subparts?
Photograph of pet cemetery and photographs of Kylie as we took her out of the ground in her burial site.
And were these photographs taken on June 9 and 10?
That's correct, yes.
And were you on the scene that day when those photographs were taken?
Yes,
Are they true and accurate representations of what you saw?
yes.
Yes, they are, Solo Sock, and I'm glad you're feeling better.
Your Honor, those exhibits having been admitted, I'd asked to publish.
Images of
Yeah, I hear the flu that's going around.
Detective, before I publish that, I'm going to place states exhibit 10A up again. Point to the general location of what you've described as the pet cemetery.
Right here.
So can you have on the record and explain where it's pointing?
Yes, Detective, will you explain where you're pointing?
It's just east of this shop area and just north of the fire pit. So it's right through here.
Not surprised at all. Walk away, Renee. Hello.
And Your Honor, I do think that the state's first picture under State's Exhibit 11 is okay for public consumption.
It is. I just wanted to make sure our system was working as well, but exhibit 11A is fine.
Hey, Lollipop Guild.
Detective, what did you observe in State's Exhibit 11A?
This is where we began excavating briefly. As you can see in this photograph, there's a small black dog statue next to the post. So that's where we had learned this was the pet cemetery area through talking to family members. And then there's just some tarps laid out for some of the soil. You can see in the back the markers that had been distinguished and laid out by ERT for the fire pit area that I had talked about earlier.
And Your Honor, I think at this point it's appropriate to turn to public access.
I agree.
Detective, Your Honor, I'm at a bit of a, I have no idea if this is, I can't see if this. Well, I'll ask Detective, can you see that image in your monitor?
Yes,
Can you see most of it?
yes.
Can you describe for the jury what's been marked as State's Exhibit 11B? What did you observe there?
Can I see? Is there a way I can use the pointer?
I have a suggestion also, Mr. Wood, just because I understand what you're doing to try to line that up since you can't see the monitor. Do you want to set a notepad or something on there, and get it oriented, and you could set on top of that just so that it's lined up?
And if I could have the screen for 1 moment, thank you, Your Honor, for that suggestion.
I know, Teresa. By all accounts, Lori was a wonderful person and a wonderful mother, and I have no reason to believe she wasn't, until all of this happened. And it is shocking. Absolutely shocking.
Detective, what did you observe in State's Exhibit 11B?
It's hard to describe that, but I'll do best. In the middle of that photograph, you can start to see the different color and changes in the soil from dry to a wet, moist dirt. You can start to see to the left just a little bit of that area. You can see the white piece sticking out and it's burnt on top, and that's charred bone that's starting to stick out, and all the little pieces next to it are pieces of burnt flesh, tissue. What we later determined were organs that were all that's the top of what was inside the bucket. So that's what we first started to see when we started to exit.
Oregon.
And at this point, were you still using the hand tools?
Yes.
You explain for the jury what you observed in State's Exhibit 11C.
So as we started to excavate down further, some of the top of the mass of burnt flesh wasn't really attached to anything. And so when we would start to dig away towards the sides, it would kind of come apart. It wasn't part of that original mass. And so what you're looking at on this blue tarp is burnt flesh still attached to some bone. The upper left part of that section that you're looking at is part of a hip bone that still has burnt flesh attached to it, and then dirt and just fatty burnt tissue.
Yeah, walk away, Renee. He's like, there's a big pasture back there on the property. There's a difference between the mowable lawn and the property.
What you observed in State's Exhibit 11D.
It's ridiculous.
So when I talked about it started to take a roundish shape, this is what I'm referring to. And we dug around the sides of it, trying to get to the bottom, because like I said, the goal was to get underneath, have 3 or 4 guys in there and just lift it onto the tarp. So that's what you're looking at in this photograph, is just the burnt flesh. It's still just kind of inside that.
And Judge, could we approach for a sidebar, please?
Yes.
Stacy, that sounds truly nightmarish. I'm very sorry that happened with your mouth. And luckily we started a little bit late, so I get to fast forward through the
They're in the dirt as well.
sidebars.
So that's what you're looking at, just a close up of the bottom of it.
What you explain for the jury what you observed in State's Exhibit 11F.
So once we removed that mass, and put it on the blue tarp, there was still some wet soil underneath. So we dug down even further to make sure that we had excavated everything we needed. And so what you're looking at, you can see the tarps in the background we had put up. You can see some of the hand tools that we used just to the right of that hole. But that's what you're looking at, is just after we got that mass out, the wet soil.
You know, Tylee was about to
Second,
turn.
what did you observe in States Exhibit 11G?
So these were part of Tylee that kind of broke apart when we tried to lift it out of the ground. There's pieces of charred bone. There's parts of a skull on the bottom left, covered in dirt, and they're still burnt, rotting flesh still attached to the bone. So that's what you're looking at that one. These were the pieces that broke off.
Yeah, it wasn't just an issue of them not wanting to take care of kids. Those kids were income sources for them. That's the sad thing.
Becca, I believe you testified that you assisted in transferring those remains to Madison County to the hospital, correct?
Correct, I followed behind in the corner.
Was Lieutenant Ball with you again?
He was.
Once you got up to the hospital, what did you do?
We observed the Fremont County coroner, Brenda Dye, transfer Tylee's remains into the morgue. The morgue was unlocked, but there was evidence they put up. And at that point, myself and Lieutenant Ball went back to the defendant Daybell's residence.
And what did you do once you got back there?
We assisted and made sure there were no other burial sites or anything that the ERT team needed assistance with. At that point, we decided that we were going to take JJ and Tylee to the Ada County Coroner's Office to have an autopsy performed. So roughly 4 p.m. on June 10th, 2020, it was decided that we were going to follow the county coroner with the remains of JJ and Tylee to the Ada County Coroner's Office for an autopsy the next morning.
And when did you arrive in Ada County, approximately?
Approximately 8 or 9 in the evening on June 10th.
And what did you do once you got there?
We went directly to the coroner's office, and JJ and Tylee were dropped off, and the coroner's office took custody of both JJ and Tylee.
Hello, Tiggy girl. It's still
So that was later in the evening.
Correct.
And was an autopsy performed that night?
No.
When was the autopsy?
The
Judge, I'm gonna object. There needs to be some foundation.
Overruled, if you know, you may answer.
The autopsy was performed June 11th, early morning hours.
Well, that was the next day.
Correct.
And were you present for that?
Yes, I was.
And where did that autopsy take place?
At the Ada County Coroner's Office.
So when you arrived at the coroner's office, what did you do first?
Initially, when we arrived, we had a little debrief with the medical examiner, Garth Warren. He told us what he expected.
Judge, objection.
Grounds.
Hearsay?
Same.
Grounds.
You met with Dr. Ward.
Correct.
What was the purpose of that meeting?
To debrief us on what to expect that morning.
What did you do next?
We went to the room where the autopsy was performed. Put the sanitary booties on our shoes, signed in on a whiteboard with our name and cell phone numbers. So he had a record of everybody that was in the room.
Yeah, you can
And at
see.
that point, we stood back against the wall and observed the autopsy.
You can see their silhouettes,
As
Teresa.
a detective, you don't perform an autopsy, correct?
Correct.
But you were able to see it take place.
That's correct.
And what did you observe happening during that autopsy?
One of his team members brought out the body bag. And I recognized it to be the same body bag that we took from defendant Daybell's backyard that day because it still had dirt on it. It still had the same lock. And at that point, they opened the body bag and revealed the same black plastic and small body that appeared to be in the black plastic.
And then what did you observe?
Dr. Warren and his team cut down the middle of the black plastic to open up what was inside. At that time, I observed a small child with duct tape on his head from his chin to his forehead area, tightly wrapped around his head. He had red pajama pants on, red pajama shirt. He had his arms folded this way across his body. And there was duct tape from elbow all the way around to his other elbow. He had his ankles also bound with duct tape. He was still wearing his nighttime pull-up diaper. He had black socks with the word Skechers in orange. I could tell that he was going through various states of decomposition based on his skin color.
Judge, I'm gonna object.
Grounds.
He
Grounds.
doesn't have the experience to make a determination about the levels of decomposition. He's speculating.
I'll sustain the objection and strike the final part of the answer about decomposition, Mr. Wilkie.
All right. Detective,
It's a very petty
what
objection.
did the body's skin look like?
The skin was sloughing. It appeared to be bluish green, black, yellow. And through my training experience, going through and handling different dead bodies at different stages of decomposition, that's what I read.
Judge, I'm gonna object again. There's been no foundation for him to make that sort of medical assessment. He's not a medical doctor.
Your Honor, my argument would be that's not a medical assessment. It makes it on his training experience.
I'll overrule the objection. If you'd like to cross further, you'll have a chance, Mr. Pryor. The
It's a-
objection's overruled.
It's a dead
Foundation
body.
laid in
It's
the previous
decomposing.
response.
Detective, once this, the body was taken out of the bag and you made the observations that you've just described, what happened next?
Dr. Warren and his team then cut the white plastic that was wrapped around his head and duct tape. They cut down the middle to reveal what was underneath. And at that point, I observed another piece of duct tape stretched from JJ's jawline to jawline over his mouth, He also cut the several layers of duct tape from his arms. And it revealed some more duct tape that had his wrist bound underneath all those layers of duct tape. He then took his bottom pajamas off and shirt, and it also revealed the nighttime pull-up diaper he was still wearing.
Now, Detective, you spoke about the duct tape and bag over the head, correct?
Correct.
And you've been referring to this as JJ.
Yes.
Until that duct tape and bag were removed, though, were you able to identify him as JJ?
No, once they removed the duct tape in the bag, through looking at all the photographs for the last 8 months of JJ, I recognized him to be the same little boy laying on that table as JJ Vallow. He had the same hairstyle, shorter on the sides, longer on top. At that point, I recognized him as JJ.
Once the clothing was removed, what did you observe happen next?
Dr. Warren pointed out some bruising on his arms, on his ankles, on his chest. He also pointed out some scratch marks on the left side of his neck, just under the duct tape. At that point, Dr. Warren and his team performed the autopsy.
Your Honor, I'd ask that the witness be shown on State's Exhibits 12A through 12B.
A through B.
E.
B, thank you.
Yeah, I've always wondered why the kids were in the state they were found, why JJ was bound, why Tylee was incinerated. I don't understand. I don't understand. I really. Exactly, destined your own flesh and blood. How sick is it that they could find a justification to do this, that they think that they are good people?
Detective, can you review those exhibits? Let me know when you've had a chance to.
You know, Lori, there's audio recording of Lori reciting Bible
Do
verses
you recognize
justifying this
State's
behavior.
Exhibits 12A through E?
Yes,
What do they purport to be?
JJ Vallow laying on the table after they opened the black plastic.
And were you present when those pictures were taken?
Yes,
You were in the same room.
Correct.
Are those true and accurate representations of what you observed that day?
yes,
Your Honor, I'd ask that State's Exhibits 12A through E be entered into evidence.
No objection, Judge.
Very well. 12A through E are admitted. All of these are graphic in nature, will not be published or shown on the court's live feed or published in the courtroom. They'll be published to the jurors, however you wish to split.
Thank you. Detective, can you describe to the jury what you observed in State's Exhibit 12A?
Dildar, we're watching a trial where two children were
once
murdered.
they removed the black
family.
plastic, that JJ Valla was in, this is the first thing we saw. You can see on the white plastic on top of his head, that's the slit that was made when his head was sticking out of the ground. And you can see the duct tape I testified to wrapped around his entire face. His red pajamas are still soaked with body decomposition. The level of duct tape on his arms is what really caught my attention. And he still has a white and blue child blanket wrapped around him.
You describe to the jury what you observed in States Exhibit 12B.
This is the JJ's legs, his bottom half, he has his red pajama pants on still. His ankles, like I testified, are wrapped with duct tape. Those are his black Skechers socks that he had on. It's hard to see there too, but his legs and body are also soaked with decompositions.
Oh, we're going to hear an objection. He said decomposition, and he's not a doctor.
You describe to the jury what you saw in States Exhibit 12C.
When I spoke earlier that Dr. Warren cut down the white plastic and the duct tape that was covering his head, this is what we saw. You can see the other layer of duct tape around his mouth that went from jawline to jawline. You can see his hair, brown hair still was matted down to his head. Wet, soaked with body decomposition. But at that point, I was able to still recognize him as JJ Valla.
Destined, I'm hoping that by the time they were duct taping him, he was already not with us.
You observed in 12D.
That's the white bag that was covering his head. It looks like blood in the bag. It's actually body decomposition, just breaking down. It appeared to be a normal trash bag. It had a red drawstring. And you can see, if you look close at the waffle style pattern, the expandable type trash bag. There's still pieces of duct tape that are attached. That's what that photograph depicts.
Destin, there's no money to be earned in doing away with Chad's adult children.
You describe to the jury what you saw in 12B.
That's just another photo of JJ. The tape is starting to lose its stickiness because of the way the body is. It's just a different photo or a different angle of JJ's face.
That's true. Walk away, Renee. He's like, I have to object. Like he's burdened with it. Well, if he was alive while they were duct taping him,
So can I have a re-sidebar, counsel?
there's a whole new level of evil there. A whole new level of evil.
Normal, we are going to take a mid-morning recess at this time. We'll reconvene here about slightly before 10:30 to get started with additional testimony.
All rise, please.
And we have caught up to their mid-morning break. We have caught up, ladies and gentlemen. So we're waiting for them to come back from their mid-morning break. And let me take this off and go like this so it doesn't look funny, and go like this. So we're just getting through this very sad, somewhat slow, graphic testimony. They've been on their break for several minutes now. They're probably going to be back any moment now. So I'm going to. Oh, hey, Kathy Four, nice to see you. You didn't miss too much. So what we just saw was, basically a couple hours, maybe hour and a half worth of testimony from Detective Hermosillo. He's basically the lead detective on the case. We've seen a lot of testimony from him over the years on this case. And he brought out a lot of evidence, and he brought out the, most, it sounds like they're really at the very beginning of the trial showing the most graphic evidence to really land the point that this is a horrific crime. Lollipop Guild says, I think he was still alive. Why duct tape his mouth and restrain him like they did if he was already gone? Just my thoughts. You're probably right, y'all. You're probably right. I'm going to be honest with you. I'm just having a hard time thinking about why and the process. And, we just know so very little about exactly how the kids were killed. All we know is how they were found. We know that Chad sent the text message to Tammy on September 9th saying that he says he shot a raccoon, right? So he was trying to cover his steps. He clearly shot something. So probably Tylee was shot. We don't know how Tylee died. Or I'm sorry, how JJ died. And they found him with, a bag over his head and bound with duct tape. If you're telling me that what they did was duct tape him and put a bag around his head and that's how he died, I want to literally pull my hair out and run around my house screaming. And I'm not kidding you. I mean, Kathy says, I actually remember this graphic evidence. So I'm relieved now that I missed some of it. So they actually didn't show it. They just described it, Kathy. They didn't show it for us. And the angles in the court views are so bad. We probably wouldn't have been able to see it anyway. But it's really, really horrific to think about what it was like. And I'm thinking especially for JJ. I'm thinking that Tylee didn't know what was coming. I'm feeling like, they had this nice day at Yellowstone, and then they were at Chad's property and they were out by the pet cemetery, and she didn't know what was coming. If she knew what was coming, she would have fought. She was older, she was smarter. She would have had an inkling of what was coming to her, and they probably just surprised her. They just came up behind her like the snakes that they were. With JJ, they were much bigger than him. He had special needs, so it was much more difficult for him to understand what was going on. And and therefore, I think they might have just done what they did to him, for lack of a better way of putting it, in plain sight, like just did it to him. And it's Stacy says, my 6-year-old nephew landed in the hospital with a bad concussion and shattered ankle, cannot mess with their schedules. Yeah. It's Kay Woodcock isn't in court today because of the pictures to be shown of JJ this morning. Oh, interesting, because it looked like she was in there, but again, it's really hard to see in the court. It's really hard to see in the court. But it looked like you could see their silhouettes by the door. I wish many people would just tell the truth. I wish many people would just tell the truth. Good morning, Jamie Lee. And good morning to anybody I haven't said hello to. They should be coming back from the break soon. So while we're waiting for them to come back from the break, did anyone else catch that Brian Kohberger hearing yesterday? The hearing in the Brian Kohberger case? It was pretty wild, you guys. So I streamed the hearing from last week where it was an emergency motion hearing because the defense was surveying 400 members of Latah County about whether they're prejudiced. So the defense had hired this, basically a marketing guy, Dr. Edelman. I'm aware of this person from my marketing background. This Dr. Edelman comes from a long and storied marketing background, marketing family. And wait, who got a bat out? Your nephew? Is that how you ended up in the ER? That's terrible, Stacy. So I'll tell you what happened with this hearing with Kohberger. So last week there was this emergency motion hearing because the defense is trying to change the venue. They believe that the county where the trial is currently slated to be held is biased, and they won't be able to select a unbiased jury. They're trying to get it changed. They're doing surveys in the county where it is currently slated, and they're getting ready to do surveys in another county, but they did not run the questions by. Oh my gosh, Stacy, that's incredible. Wow. They didn't really the defense was not team players with the state in the survey questions. And they went out and asked questions in the survey that were incredibly prejudicial. They asked wrong questions. They asked questions from the probable cause affidavit that introduced bad facts into the public sphere, right? And so they ended last week's hearing deciding to have another hearing where they bring this Mr. Edelman to describe, the methodology for the survey and everything. And so that's what the hearing was yesterday. But to me, it was a complete waste of time. The entire thing was a waste of time, because what the defense is trying to do is say, we want to keep doing this survey. And nobody is saying don't do the survey. What the state is saying and what the judge is saying is do the survey, but do it responsibly. Do it in a way that doesn't, ask really prejudicial questions. And it actually did help me too, Kathy. So they had this Edelman guy get on the stand. He explained it. It really did help you understand the methodology and why it's important to get these surveys done. I don't have nobody has the issue is that nobody's pushing back on the idea of having a survey. Nobody is. What they're pushing back on is the way that it was done, that it was basically done behind their back. There was an agreement. There wasn't agreement as to how, what questions were asked. And there, it's just that the defense is not being team players. So now we have to have these delays for these hearings to hear the justification for things that there's no need to justify. It's just get agreement on certain things in the first place. Then you won't have to have these hearings to justify things that we already agreed to do. So to me, it was this colossal waste of time, even though, yes, we got to learn more about this, process. But, I actually think that there is a little bit more to it than we think. Coming from a marketing background, right? And listening to what this guy was describing that they are doing, he's making a huge amount of money on this project. Okay. Him and his team are making they're making six figures, no question, on this project. And that's coming out of the state's budget, right? And so this is not just a concern of time. It's also a concern of, is this the best way to spend our resources? And they just did it with one county, and now they're planning to do it with 2 more counties. Is this the best way to spend those resources? And so I think that's what a lot of the conversation was about. But it's amazing to watch an entire court hearing take place and hear the the defense and the state. They're really getting angry and irritated at each other. They were taking headshots at each other. They were getting personal at each other. They of course they never get to the level of like a couple YouTubers going at each other, but they were throwing shade at each other about, just really pointing the finger. And I have to say that the judge was not helping because he was being incredibly indecisive. And he wasn't taking much charge of the conversation. He's basically allowing the 2 lawyers to, it's like it's almost like he's waiting for the lawyer with this stronger feeling argument to dictate his decision. I don't know what it is, but he's not a super decisive judge, you know. And even if he is decisive, he takes a long time to decide. So, you know, if they change venue for this case, it'll go to a different judge. And I almost find myself kind of hoping that, because if we are going to be going with judge this whole time, I don't know when this case is going to ever end up in court, in a trial. I mean, it's just taking for gosh darn ever. And a lot of it, I sort of believe in the back of my mind that Ann Taylor is getting exactly what she wants, which is delay. So, what was going on there What if that window photo is real and those other kids were involved? They currently got one man behind bars. I believe he belongs there, but what about the others that could have been involved? The window photo. I haven't heard about a window photo. And granted, I don't follow the Kohberger case, day by day by day. Is there a window photo? Is there a window photo? And while we're sitting here waiting for this to take place, I know some of you follow my other channel as well, Checkmate Humanity. I'm starting to just get so incredibly tired of the way true crime is being covered in the true crime community. There shows a bunch of boys looking in Maddie's window. Really? I've never heard of this, ever. A bunch of boys looking in Maddie's window. I've never heard of that. Never, never, never. Look at if you have watched the Apple River murder trial, the Apple River tape video, the 5 people in that situation were stabbed within seconds. Literally within seconds. One of them was mortally stabbed in his chest, and it was not with a K-bar knife, okay? It was with a pocket knife that the guy pulled out of his swim trunks, all right? Pulled it out of his swim trunks, opened the blade, and just started jabbing. One guy, trigger warning, was disemboweled, okay? Within seconds. And that wasn't even planned. So let's just say that Brian Kohberger planned this. It is not difficult for me to believe that somebody, let's just even say that it wasn't Brian Kohberger that planned it, but somebody planned it. And they used a K-bar knife to do it. Yeah, the Apple River guy didn't just stab, he sliced. He went in and he sliced. He went in and up. Okay. Yeah, there's definitely room for it. There's definitely room. And hey, I'm open to opinions. I'm not one that sits here and says, "You're not allowed to have that opinion and get out of here because you have that opinion." What I'm saying is, it's not hard for me to believe that someone tall and fit and young and obsessed, and full of adrenaline, who had planned it out, could very easily, with a large knife, kill 4 people within that period of time in that house on their own. I do believe it. And in fact, if there were 2 people, if there was more than 1 people, probably the other 2 roommates wouldn't have survived. Because why leave witnesses? But he was, kind of green around the gills in his, if he's the right guy. If he's the right guy, he's not really an experienced killer that we know of. And he either didn't see her as he was leaving, or he froze himself and said, I'm not going to be able to get away with this one too. And passed her by and left. So I don't know. That's where my head's at with this. But I'm also open to other possibilities. It's interesting that they're taking this long to get back. So I've been looking at let me make sure. Yep. I've been looking at the feed for the Nicolae Miu trial, and there's no verdict there yet either. No update there that I can see. Ooh, wait, hold on a moment. Uh-oh. There is a verdict. There was a verdict in this case. Let's look at it.
Please be seated.
That's a fast verdict.
Based on the unanimous verdict, I will enter convictions on each of the 6 counts. Bail is revoked. Mr. Miu will be held in custody pending sentencing. My staff will contact the attorneys and will schedule the sentencing date. I will order a pre-sentence investigation report and decide to discuss this case with anyone. Please. All right, please be seated. All right, we are back in session on the record in State of Wisconsin versus Nicolae Miu. The attorneys are present with Mr. Miu. 12 jurors are in the courtroom. Mr. Ashland, I understand you are the foreperson.
Correct.
Did your jury reach a verdict?
Yeah.
Did you reach a verdict on each of the 6 counts?
Yes, we did.
Okay, please hand the verdict forms to the bailiff.
That was a fast verdict. Wow. That was faster than I thought it would be.
Verdicts read as follows. As to count 1 of the information, Isaac Schumann, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted.
Wow.
Question, did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes.
He toasted him.
As to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 3 of the information, Dante Carlson, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 4 of the information, Anthony Carlson, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 5 of the information, Riley Madison, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 6 of the information, Madison Cohen, The jury finds Nicolae Miu guilty of battery as charged. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. Members of the jury, I do have to verify that this is in fact a
Alrighty, there you have it. I agree with it. I agree with it too. That guy toasted himself with his testimony. All right, let's head back to Daybell. All right. They are back underway. We can fast forward.
We're back on the record then on case CR 22-21-1623, just concluded the morning recess. Detective Colonel CEO is still under oath, and Mr. Wood, if you'd like to continue with your direct, you can do that at this time.
Thank you. Detective, I think when we left off, we were speaking about the autopsy of J.J. Bell, correct?
Correct.
You had mentioned earlier that you did observe the actual, not only the body, but then the autopsy of J.J. Bell.
That's correct.
And were you present for that entire autopsy?
Yes, I was.
And when that autopsy was concluded, what did you do?
At that time, Dr. Warren and his team removed JJ from that autopsy table. Then they brought out a second, excuse me, black body bag. And I recognized it to be the same body bag from the scene because it also had dirt. And they placed that body bag on the table.
And what did you observe next?
Dr. Warren and his team opened the body bag, looked at the remains for what was left as far as remains inside. He stated there was nothing he could do at that time with an autopsy, so.
Judge, I'm going to move to strike as hearsay,
Your own statement already came through.
and I'm going to move to strike.
So
Drive carefully, Stacy.
Could you repeat the question?
What did you observe? What were you had just talked about the Tylee's remains being brought out. What did you observe?
Once the remains were brought out, Dr. Warren opened the bag and looked at the remains and stated there was nothing he could do at that point. So at that time, we left the autopsy room for the day.
And when you left, did you do anything in furtherance of your investigation that day?
No,
Did you return to the Ada County Coroner's office the next day?
we did. On June 12th, 2020, we went back to the Ada County Coroner's office. At that point, Lieutenant Wall took custody of some of the evidence and we transported it to the state lab in Meridian.
And were you with Lieutenant Ball when you did that?
I was, yes.
And once you took it to the state lab, what did you do?
Those items were checked into the state lab. And then that concluded what we did for that day.
Detective, you spoke earlier about some of the other agencies you've worked with in this investigation. And is it correct you worked with Fremont County?
Correct, yes.
And I believe you testified that your primary focus in this investigation was looking for Tylee and JJ. Is that accurate?
Yes, that's accurate.
Was there an investigation in Fremont County at the same time that had connections to your investigation?
Yes, there was.
What was that investigation?
Fremont was investigating the death of Tammy Daybell, who was married to the defendant, Chad Daybell. Kind of the exact same time we were doing our investigation with missing children.
And would you meet with Fremont County and discuss the cases together?
Yes, we would.
And would you aid each other in those investigations?
Yes,
Would you share information?
yes.
Detective, are you aware of any event involving Tammy Daybell on October 9th, 2019?
Yes, I am.
How did you become aware of that event?
Through the course of sharing information with the Fremont County Sheriff's Office, we were advised.
Judge, can we approach?
Yes.
Sidebar.
And then I'll see if that Mr. Wood's previous question before the sidebar, and then I'll see if there's an objection held by defense.
Question, how did you become aware of that event?
Is there an objection to that, Mr. Pryor?
No, not to that question.
Okay, then Mr. Wood, just proceed with another question.
I don't think there's no objection to the question. I don't think it's been answered yet.
Okay. You can answer.
We were advised through the course of our investigation that
Judge, I'm going to object at this point. The question is whether he was advised, not what he was advised of, but whether he was advised.
Our response, Mr. Wood?
I'm not quite sure I understand that objection, Your Honor.
I don't as well, so you can continue with your response.
Can you repeat the question, please?
How did you become aware of the events of October 9th, 2019?
Through the course of our investigation, we were aware of those events through speaking with Fremont County Sheriff's Office.
Why was it important to you in investigating your case to share information and receive information from Fremont County?
It was important because the suspects in that case were the exact same suspects in our case. And so we wanted to make sure that we shared information so nothing was missed. At that point, we were still looking for two small children. And so it was imperative to us that we shared information and gathered information from neighboring counties and anybody that was involved with this case.
And did you also confer with Arizona law enforcement?
We did, yes.
Detective, are you aware of who Charles Vallow?
Karen Pryor.
Yes.
Who was he?
Charles Vallow was married to Lori Vallow.
Is he alive?
No, he is not.
Do you know when he died?
Charles died July 11th, 2019.
Are you aware of how he died?
Charles was shot by Alex Cox, Lori's brother.
Now, you testified earlier that your initial involvement in this case involved looking for a Jeep.
That's correct.
And I believe, correct me if I'm wrong, I believe you testified that you were looking for that Jeep because it was requested by Arizona law enforcement.
That's correct, yes.
And are you aware of why they were looking for that Jeep?
Yes, I am.
Why were they looking for that Jeep?
That Jeep was a suspect in an attempted homicide of Brandon Boudreaux, who was Lori's He was married to Lori's niece, Melanie Boudreaux. The suspect in that homicide was also Alex Cox.
Detective,
I'm showing you Brandon Brood.
going back to October 9th, 2019, Tammy Daybell. Are you aware of the incident that took place with Tammy Daybell?
Yes, I am.
What was it?
Judge, I'm going to object. There's no foundation as to how he became aware of it.
Sustained.
Through your investigation, did you become aware of what happened to Tammy Daybell?
Yes, I did.
And how did you become aware of that information?
Sharing information with Fremont County.
And so was this part of the collective knowledge of the case that you were working?
That's correct, yes.
And did you aid in that investigation as well?
I did.
So you personally became aware of these events?
Correct.
Based on your knowledge and your investigation, are you aware of any event involving Tammy Daybell on October 9th, 2018?
Judge, again, there hasn't been proper foundation.
I think at this point I've established that it's through his investigation and knowledge.
This objection's overruled.
You can answer the question.
Yes, I'm aware.
And what was that event?
On October 9th, 2019, Tammy Daybell believes that she was shot at in the driveway of the defendant Daybell's residence.
And when you say shot at, are you aware of how she thought she was shot at?
She initially reported that it was possibly a paintball gun.
And note that this was 10 days before she actually died.
Detective, in your investigation, did you ever put together timelines of events that took place?
Yes, I did.
Why is it important to do that?
Just to establish who the key figures were and the key dates to aid in our investigation, so we can make sure that we share the accurate and correct information with the other agencies.
And in preparing for this trial, did you prepare any charts of key figures to aid the jury in understanding your testimony and the testimony of the trial?
Yes, I did.
And was that based on your involvement in the case
Yes,
and your investigation?
correct.
And based on I'm sorry, that wasn't very well said. Based on the information you gained from your investigation.
That's correct.
Your Honor, I'd ask that the witness be handed State's Exhibit 30. You have State's Exhibit 30 in your hand.
Yes, I do.
What does it purport to be?
Those are the key figures that I put together as far as the investigation goes, photographs.
And did you do that to aid this jury in understanding who the people involved in this case are?
Yes,
And did you do that in anticipation of your testimony?
yes, I did.
And are those, the pictures attached with those names, are those true and accurate representations of the individuals attached to those names?
Yes, they are.
Your Honor, for demonstrative purposes only, the state would move to enter State's Exhibit 30 into evidence.
Any objection?
For demonstrative purposes, no.
Very well. Exhibit 30 is entered for that reason.
Oh, Elaine.
And publish.
Yes.
Detective, if you can just use your pointer and just, for purposes of the record, read the names attached with each picture.
Sure. This is Lori Vallow Daybell, Charles Vallow, Alex Cox, who's Lori's brother, Chad Daybell, Tammy Daybell, his deceased wife, Tylee Ryan, who is daughter to Lori, JJ Vallow, who's a son to Lori, and Melanie Pulowski Boudreaux, she was remarried, is the niece to Lori Vallow.
And when you say that JJ was Lori Daybell's son, was he also Charles Vallow's son?
Yes, he was.
And that was by way of adoption, correct?
That's correct.
And so Alex Cox was JJ and Tylee's uncle.
Yes.
Detective, similar to that last chart, did you prepare a timeline in anticipation of your testimony?
Yes, I did.
And did you do that based on your experience and knowledge of the case?
Yes, I did.
And it was based on information you gained through your investigation?
That's correct.
And did you do that to aid the jurors in understanding just the basic timeline of the events that happened in this case?
Yes.
Your Honor, I'd ask the witness be handed State's Exhibit 31.
Judge, could we approach please with sidebar?
Yes.
Sidebar time. So, and we are all caught up. So, in case any of you have not heard, Orenthal James Simpson is no longer with us. He is deceased at the age of 76. He died of cancer. There are no thoughts and prayers going out to him today from anywhere that I have noticed. Those are the reports. It's actually kind of satisfying to just see people just saying, yeah, he's dead. You know what I mean? Bye. You know, it's not like I'm not the type of person that's like, dancing on a grave or anything. There are people who love him. I don't want to make it worse for them, like his family. But let's face it. He brutally murdered 2 people and got away with it. Dude was a piece of work. The thing is there didn't even need to be a deathbed confession. He wrote a book confessing it called If I Did It. That was him basically laughing in the face of all of the survivors of that catastrophe. I mean, that is in your face being a sociopath. That is a sociopath. Getting away with murder and then writing a book, if I did it, this is what would have happened. And then he does end up going to jail for armed robbery for trying to steal back his own collectibles. He was a freaking psycho. Somebody should study his brain. That's what they should. If he was really, yeah, then he partied like a rock star. What somebody should do, it, if he really wanted to do good for the world, he would allow them to take his brain out so they could study it and say, let's figure out how to make sure no one else is ever born with a brain like this. That's right. He did, Tiggy Girl. I didn't read it, but that's exactly what the book was for. That book was Duper's Delight on steroids. Also, if you missed it, we just reviewed earlier that Nicolae Miu from the Apple River stabbings trial was found guilty on all counts. And I'm personally relieved because, after I was really on the fence in some portions of that trial, watching that trial go down, because the kids in that scenario really acted horribly. But again, they were kids, they're children. You have to take that into account. They are children. He's 52 years old. Also, it was hard to tell who struck first, even though a lot of people testified that he struck her first. You couldn't see it. You couldn't see it on the video that had a lot of other evidence. This video had a lot of evidence, but you couldn't really see who struck whom first. But to me, he had many chances to walk away, and he lied. He lied and he lied and he lied and he acted guilty. And he made the mistake of trying to testify in his defense. And my understanding, and I'm seeing that now that I've been covering these trials, that it's very common to testify and
This time, ladies and gentlemen of the jury, there's an evidentiary issue to
Uh-oh.
resolve, which we are going to take up outside of the presence of the jury. We'll do that as quickly as we can. So I will be out the bench while I research this momentarily. Then we'll come back on and make a ruling outside of the jury's presence, bring them back in to evidence.
All rise, please.
That's cool, Solo Sock. 65 Chihuahua, 22 Small Poodle, 8 Cocker Spaniel, 5 Volpino Italiano. I've never heard of Volpino Italiano either. So they're going to take up an evidentiary issue. I wonder if it's interesting evidentiary issue. That's my doggy. So now you've heard the little dog next door, and you can hear my dog, who is the sweetest, most gentle golden doodle you've ever met. But he sounds like a German Shepherd.
Maybe seated.
I really feel bad for this detective, but I'm hoping that after this testimony that he gives today, he gets to walk away from this case once and for all. Because he's been on this case since 2019. and he was right there on the scene when they, recovered the remains. He was in there for the autopsies. So I think also one thing we can say, yeah, me too, Evil Queen. One thing we can say about John Pryor is that he has been giving his client a rigorous defense. I think with John Pryor, we're seeing a preview of the kind of defense that Ann Taylor is giving her client. It's very, very similar. Stall tactics, whiny, aggressive, you know, making excuses that stall. I just kind of see them using the same techniques. I wonder if they've ever worked together. So you got the DNA kit when you signed up with BarkBox. That's cool. So I wonder, are they now, I guess they're taking up the evidentiary issue also off the record in chambers, because everybody in the courtroom's just hanging out. Even Detective Hermosillo is just hanging out on the stand. So another thing that happened in the courts recently was that the Crumbleys were sentenced. You know who else was sentenced recently? And it was quite the sentencing. Was Taylor Shabiznis. Do you remember Taylor Shabiznis? She is the girl who was found guilty of killing the woman that she was a caretaker of and stealing her money, embezzling her money. And she was quite the drama queen in court. She was very erratic and emotional. She demanded a lot of attention. Well, and she also had the same judge as Darrell Brooks. She was in Waukesha County. So her sentencing was something like 2 hours long. And one of the reasons is because Taylor Shabiznis gave like a 1 hour long statement. She read an hour long statement talking about her innocence and how, it was very, very, she read 2 letters that the victim had written. I know, Shabiznis. No, she murdered her. She's convicted of murdering a family friend that she was taking care of by putting Visine in her in her water or her vodka or both. But wrong convict? Oh, shoot. I'm sorry. I'm missing things up. I apologize. You're right. Yeah, okay, I'm sorry. Well, the one, whoever it was, if it was Jesse Krasuski, the one, Taylor Shabiznis was a beheader of ex-boyfriend. Oh, that's right. Oh my gosh, you're so right. You're so right. I am so sorry. Jesse is the one who put the Visine in the liquid, poisoned her person she was caretaking. Taylor Swift business. Krzyzewski. Yes, that's right. Krzyzewski. So Jesse Krzyzewski was sentenced. She gave a very long statement. Judge Darrow was the judge, same judge as Darrell Brooks. Woman has the patience of a saint. Yes, you're right. Taylor Swift was the one who beheaded her boyfriend. Yes. And her boyfriend's package. Yes. Oh, that was so gross. Oh my gosh. So, but the she gave a very long-winded, whiny, excuse-making statement to the court. She basically tried to try her case again right there in the court. I forget what weapon Taylor Swift tried to use with her boyfriend. I forget what she used. Ugh. They were on meth, those two people. But really the reason I'm interested in, watching people in court is because you see, courtrooms are where people are supposed to be on their best behavior. They're supposed to bring their best game, the stakes are high, people's lives are on the line. Was it a bread knife? Oh my God. Oh, Jesus. Walk away, Renee says, someone I worked with when I was 19 put eye drops in a customer's drink at work. Oh my God. He was fired because we let our boss know, but I didn't realize it could kill someone. Walk away, Renee. Why would they put eye drops in a customer's drink at work? Why would they do that? That's so weird. Yeah, Darrell Brooks cannot be mistaken as anyone else. That's for sure. But one of the reasons I like doing these court streams and covering court cases is because it just amazes me to watch people in court and how they behave and how they present themselves when they're supposed to be on the top of their game and their in their best behavior when lives are on the line. And the way some people will behave themselves, what some people will do is just incredible to me. In the name of law and justice. Yeah. He was just trying to give a difficult customer diarrhea, if I remember correctly. The rest of us were shocked and would never mess with someone's food, no matter how difficult. Yeah. Oh my gosh. I wonder if anyone's ever messed with my food without me knowing. I'm not a terrible customer anymore, but a long time ago, I was one of those terrible customers that would just find fault with anything. I was like, ugh. And so I'll bet that something found its way in my food at some point. Yeah, well, people find out that they can kill people with Visine and then they start doing it. It's like oh, wow, I didn't know you could kill people with Visine. I can just put Visine in somebody's drink and kill them. And then they start doing. That's one of the, double-edged swords of bringing awareness to true crime is that, yes, we're making people aware of the dangers, but we're also teaching criminals how to be criminals, right? if you ask for extra pickle, you might give 50. Well, that's nice. That's actually nice. Yeah, well, Letitia Stout, I mean, she tried to act, that was her mission in life, was to act crazy, to be disruptive. That woman, some people act crazy just for the sake of acting crazy and to get attention. Yeah, and that was a long time ago when I was like that. I give servers respect and courtesy now because they have difficult jobs. They have to deal with a lot of times they have to deal with really cranky, not very nice clientele, and I don't want to have to add to that. There was another thing. There was another thing. There's another trial going on that's been going on for months now, you guys. This Young Thug trial, Young Thug Life, and a couple weeks ago, I was going to go over this with you, but I ended up having to cancel it, and then it got stale. But this witness showed up one day in that trial, literally whacked out of his gourd, could barely keep his eyes open. He was nodding off in the courtroom. And yes, high AF solo, right? And it was, I found myself wondering, how could they allow this guy to testify? It was clear. He even admitted he was high. He said out loud with his own mouth that he already got high. Yeah, he admitted it. He said he was high. So I found myself, and he was on the stand for quite some time that way. So how can that testimony be admitted? Yeah, I mean, it probably felt good, right, Kathy? You know, I wasn't able to, the judge just allowed it. I mean, I didn't see any interference or like the judge allowed it. The judge allowed it, and I don't know, we have no idea what might have happened leading up to that. Maybe he showed up high before and they told him to go home, and they finally realized they decided that his testimony was so important that we're going to have to get him to testify high or not. It's either he testifies high or he doesn't testify. Yeah, $10 a day, and they're going to be there for months and months and months. And also the judge in that case is very animated. Yeah, she was on something for sure. Kayla Montgomery, Walker Ray Renee, she sure definitely was on something. It felt a little bit more like hers could have been like a methadone treatment, something that was jail supervised. Oh, it was a sight. And I would be showing all this to you right now, but I hesitate to pull away from this because I don't want them to start back up again and us miss anything. But I'm starting to wonder how long they're going to take doing this. Um, it was crazy. He was so high. This guy that was on the stand was way more high than Kayla was. he was like leaning back in the chair and his head was rolling around and you could barely understand him. It was crazy. And then the judge and on a completely different day, the judge and the one of the defense lawyers, there are several defense lawyers. One of the defense lawyers got into it. And then yesterday, the judge and one of the defense lawyers got into it. And so I feel like things are getting very, very testy. Here, okay, I'm going to go ahead and look for this stuff just to show you.
Did you just hear us talking about this incident of the car careening into the side of the laundromat?
How you saying it plays something? I don't remember though.
And did you hear you
Look
explain
at this guy.
that the case involving Mr. Dotson was totally dismissed?
Look at, he can't keep his eyes open. His head's rolling around.
I don't recall, sir.
And for you, the case involving the armed robbery or attempted armed robbery or the aggravated assault on Mr. Dotson was dismissed. You pled guilty under Alford to aggravated assault on the 3 police officers and fleeing and attempting to elude. True?
I don't remember.
And then I asked you way direct Mr. Dotson.
I don't recall, sir.
And then you explained, you just heard that you explained that we qualified that, you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now.
Oh my God. You hear that?
Yes, you may.
I'm so hot. Can I get some water? I'm so hot. Look at this. Watch this again. Look at
Did you
this.
hear you say that?
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may.
See, and the judge doesn't do anything. Nobody does anything. They're like, okay, we're going to go ahead and let this guy continue testifying. He stays on the stand. Look. Like right here.
And can you tell us what that meant?
Like, he can't say,
You were driving the car.
January 22, 2023 is approximately 5:03:30, Your Honor. Yes, sir.
I mean, would you, unbelievable. Look, I wonder if he's looked back on his own testimony in this and been like, oh my God, I was so fucking high. How could I show up there so high? They're still not back in the Daybell courtroom. So I'm going to show you where the judge and the Yeah. You see the fiery judge here.
All right. Mr. Short, I'm in possession of your motion limit, which you did remind me of yesterday, or initially say yesterday. But how long have you had this particular tape or knowledge of these particular instances? That's my first question to you. You got them in discovery, correct?
Sir,
Did you get them in discovery?
yes, the prior.
Okay, then why are you just now, yesterday, telling me orally and not doing what you did in your motion so I could kind of take it up?
What, I did do it in my motion.
No, you filed a motion, but you could have filed this thing months ago.
Your Honor, out-of-court statements are not admissible at trial.
Okay, that's not what I asked you, okay?
They're
If
not-
you believed it was going to be an issue, you could have filed this same motion 3, 4, 5 months ago, correct?
It's not.
Yes or no?
If you want me to say yes, yes, Your Honor.
Okay, that's my point. That's my point about being a forewarned judge is a happy judge, okay? Because we are now taking time out and I'm putting the jury in the back on something that you told me yesterday about, but you could have memorialized this in a motion more than 3 months ago, probably last year. And I could have taken it up and I could have ruled on this. I don't have any problem with that, but this is an example of something. If you want to do something like this, go ahead and file the motion. You should have filed it months ago. That's what I'm annoyed with.
Okay, in Your Honor, the state.
And that's what it means to be prepared as an advocate.
Okay.
The state's giving you this, okay? You knew about these,
Honor, the state.
you knew about this issue, right?
Perhaps the state, knowing that it's an issue, would not want to admit evidence of an individual being a prosecutor
I get
and
it.
a defense attorney on the same
I get it,
time.
but
So
you know.
perhaps it's not on me. Perhaps the state should not be.
Oh,
trying to admit-
it's on you,
Okay,
and it's on them.
me.
It's
always
on,
me.
it's on,
It's on me.
you know what? It's on you because you could have filed this thing months and months ago. And you could also had a conversation with the state,
I have.
okay? And are they going to use this particular information?
You'd have to ask them.
Well, that's not what I asked you. Are
cannot
they
speak
going
for
to
the state,
use
Your
that
Honor.
particular information?
I cannot speak for the state, Your Honor.
Okay. Do you see the problem or the issue that you filing this untimely motion has caused? Yes or no?
You're not going to like my answer, so I'm just going to remain silent.
That's not being an advocate, because if you can give me a reason as to why you waited months and months, because you probably, when did they give this interviews? The first interview or note that you were gonna, about the proffer agreement with Mr. Chada Jimenez.
The proffer agreement was in the first round of discovery in July of 2022.
Okay. When was the other interviews that were made from 2015 turned over?
July 2022.
Okay, so arguably, Mr. Sharp, this could have been filed sometime in 2022 or early 2023 when we started having these particular motions. Your colleagues, you filed several motions, several preliminary issues I've had to take up. So that's what I'm telling you in terms of just having to stall the proceedings so I can go ahead and take this up.
I'm not trying to stall anything, Your Honor.
No. And I don't mean you. Listen. I don't mean you like just filing this to stall it. Okay.
Okay.
All right. But
The state has.
you filed it. But my angst with you. I don't have any angst with you filing a motion. I don't. I'm just annoyed that you didn't file it in 2023.
The state has been fully aware that their colleague, who was a gang prosecutor, was serving as a defense attorney on this case. And
Okay, but that's
understand why it's my job to flag that issue. But I have flagged the issue.
okay.
And so if I'm going to take
Now
the brunt of it, I will.
you flagged the issue now on the 10th of April of 2024. Have a seat, sir.
Okay, thank you.
State, are you going to be using this recording involving, I'm going to mark.
So that's the way it's been getting. That's the way it's been going in that courtroom. It's been getting testier and testier and testier, and the defense lawyers are firing back. They're feeling like the judge is favoring the state, but I've seen the judge go on at the state as well. And Tiggy Girl, the rest of what he said was, he said, "I'm so high, I'm going to fall asleep on y'all. I'm so high, I'm going to fall asleep on y'all." All right. They are still, I'm going to show you, they're still not back. They're still, Detective Hermosillo this is what it looks like in the Daybell courtroom right now. They're still hanging around just exactly in the same position they were before, sitting there waiting to deal with this evidentiary issue. So what I'm going to show you now is James and Jennifer Crumbly were sentenced the other day. And apparently they gave speeches. And I'm interested in hearing what they had to say for themselves. And I haven't heard this yet. So let's take a listen and brace ourselves, because I'm sure I'm not going to be super thrilled by anything they have to say.
I don't know if I'm allowed to. Okay, it's okay. She said she's okay. Go ahead, Ms. Crumbly.
I sit here today to express my deepest sorrow for the families of Hannah, Tate, Madison, Justin, and to all those affected on November 30th, 2021. The gravity and weight this has taken on my heart and soul cannot be expressed into words. Just as I know there is nothing I can say that's going to ease the pain and suffering of the victims and their families. There's a quote I heard that rang true. Grief. For those of you who understand, no explanation is needed. And for those of us who do not, no description is possible. I've taken countless nights of lament over the anguish and shame I carry, knowing what my son did, the harm he caused to innocent lives, the families, and to the entire Oxford community. I pray all the victims are the embodiment of God's mercy and peace, and that he heals your broken spirits. When I was on the stand, I was asked if I would have done anything different. I was horrified to learn my answer I would not have was completely misunderstood. That answer is true because my son did seem so normal.
Misunderstood. Now she's going to sit here and try to justify that answer. Oh God. Oh God. Oh God. You know what? They're coming back they're about to come back in the Daybell courtroom, but they're not quite back yet. So let's keep listening.
I didn't have a reason to do anything different. This was not something I foresaw. That was the intention of my answer and how I interpreted the question. With the benefit of hindsight and information.
That's the entire problem. Oh God. All right, we're back here now.
All right, we are back on the record on CR 2221-1623. We are going to take up an objection outside of the presence of the jury as it relates to the state's proposed exhibit, in this case, particularly state's proposed exhibit 31. And the court had to go back and review some prior rulings in the case that occurred some time ago. I've done that now, so what I'd like to go through is the proffer and determination if there's still a objection to the exhibit and make a ruling on that outside of the jury's presence. So Mr. Wood has offered exhibit 31, which is a timeline, and Mr. Pryor, does the defense maintain an objection to the admission of that timeline?
Judge, I spoke with Ms. Blake.
I spoke with Ms. Blake, and procedurally, I think at the time that the 404B was filed by the state, we were also dealing with the severance issue, is what I recall. And then she discussed that with me. So I think I may have made a a non-objection to the 404B. And I think I made a record of that when Mr. Thomas and Mr. Archibald were objecting to that. So I may forego my objection because I think my recollection is I don't have a record of it, Judge, which is a little unusual, but I think I may have noted on the record to the court that I'm not objecting to the introduction of the 404B evidence.
All right, I understand. I think there was lodged an objection back February 14th of 2023 by you to the 404B motion. Does the state have any clarification on that, Mr. Wood?
Your Honor, just based on recollection, I believe it was not an objection to all of the state's intended 404B, but to some of it. And my recollection, and I'm not looking at any document, this is just my recollection, was that the defendant did stipulate to some of the 404B, including issues dealing with Charles Fallow and Brandon Boudreaux. That's my recollection.
And Judge, my recollection is that I did file a timely objection, but then at the hearing, there was, and I'm going back, Judge, and we're talking 3 years ago, and I'm just going off of recollection as well. That's Mr. Wood is. I believe that I filed an objection, and then at the time of the hearing, I may have orally stated that I'm not objecting to the introduction of the Brandon Boudreaux or the Charles Fallow information, and Mr. Thomas and Mr. Archibald continued theirs, and the hearing was continued on, and somewhere in the interim, Judge, there was a severance order granted, and I don't know whether I was part of the 404B motion. That's where I'm having some difficulty in recollection. My records don't show an order that you granted the 404B in this case, so I don't see an order in this case.
Okay, so just to clarify, there was an objection was filed on behalf of Mr. Daybell by Mr. Pryor, February 14th, 2023 to the 404B. We then had a hearing on the 404B evidence on February 22nd, 2023. The court then issued an oral ruling on the record, and in that oral ruling went through different evidence that was sought to be proffered under 404B. And among the rulings the court made on the court minutes under paragraph 9, specifically referencing consideration of the shooting at Mr. Boudreaux, the court weighed out the 404B arguments and found that it would be admissible at trial. And then in the hearing, I did indicate that I'd gone through the analysis for 404B, looking at the State versus Fox case, doing a two-tiered weighing of the factors, balancing them out with the evidence proffered, and ultimately, and I'm looking at the transcript of this hearing where I made the oral ruling, determining finally, quote, the court does find there is relevance under tier 1, parts 1 and 2 for the introduction of that evidence. And then I looked at rule 403 to see if there was probative value to substantially outweigh the danger of unfair prejudice, and finally determined that as to the attempted shooting of Brandon Boudreaux, there would be more probative than unfairly prejudicial, as it would relate back to the purported plan of the defendants. So the court did find that the state was permitted to introduce that 404B evidence. So as we stand here, knowing procedurally that's the ruling, on the timeline, I guess I'll first come back to this proposed exhibit 31 and ask if there's any objection at this point for the defense, Mr. Pryor.
No, Judge.
Okay, so exhibit 31 then has been offered and will be admitted. I would also note on the record that I think the door has been open to discuss that anyway based on opening argument as well, but for that reason and also based on the court's prior determination made, I am going to permit that reference on 404B evidence. The reason I'm still discussing this for council is I think this now triggers a requirement that I give a limiting instruction to the jurors about how 404B evidence is considered. And I do have prepared a limiting instruction that I am going to advise them of at such point as after your exhibit's been offered, Mr. Wood. Okay. Okay, thanks for the delay there. We can bring the jurors back in, please. This is,
I don't know where the,
I've got the actual.
and Judge, if I could just quickly inquire before the jury comes back in, if the court did have both pages of that in its,
I only have first page.
okay, once we get done with this witness, I'll bring that up.
Okay.
Totally understandable, Kathy Four. It's hard that
All right.
trials can't be more in a pace of storytelling than, linear legal timeline format.
Jury is present and accounted for.
All right, thank you. Please be seated. All right, ladies and gentlemen of the jury, apologies for that delay. We were working through an evidence issue. I will note that the state has offered exhibit 31, which has now been admitted by the court. It's a timeline. It does make some references in there that for me at this time, I think would be best to give the jurors a special limiting instruction. So I'll read this instruction to the jurors at this time. Ladies and gentlemen, during the course of this trial, evidence will be introduced for the purpose of showing that the defendant committed acts other than for which the defendant is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character.
Say bye-bye,
or that the
OJ.
defendant has a disposition to commit crimes. Rather, such evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So that instruction provided, Mr. Wood, if you'd like to proceed with that exhibit you missed.
Just trying to keep ourselves awake during a very slow-paced trial. See that
Yes.
Nicolae Miu is guilty, Chopper?
Just briefly before I do, Detective, before we took a break, we spoke about timeline you had prepared.
Correct.
And the reason you prepared that was to aid the jury in understanding the events of this case.
Yes.
If you can take your pointer and go through these events and just read them into the record.
July 11th, 2019, Charles Vallow dies. September
Yep, that's
2nd.
that's
to
where my
September
timeline
3rd,
would start.
2019. Lori, Alex, and the kids, JJ and Tyler, moved to Rexburg, Idaho. The last known proof of life for Tylee was September 8th, 2019. The last known proof of life for JJ was September 22nd, 2019. The attempted shooting at Brenton Boudreaux, Gilbert, Arizona, or attempted homicide, October 2nd, 2019. The attempted shooting of Tammy Daybell, October 9th, 2019. The death of Tammy Daybell, October 19th, 2019.
And if you'll continue on the second page.
November 1st, police receive a call about a Jeep. The Jeep is located November 4th, 2019. Chad and Lori get married in Hawaii, November 5th, 2019. Welfare check on JJ, November 26th, 2019, which is the same day Alex and Chad were contacted. The Rexburg Police Department searched Lori and Alex's apartments November 27th, 2019. Search warrant served on the Daybell residence was June 9th on 2020. JJ and Tyler were taken to the Ada County Coroner's office June 10th, 2020. And the autopsy was conducted June 11th of 2020. Thank you.
Your Honor, I have no further questions for this witness at this time.
All right, thank you, Mr. Wood. Mr. Pryor, cross-examination.
Judge, would the court like me to start, or would you, or like to take a break, a lunch break?
Let's go ahead and get started with cross and go till it was, please.
Good afternoon, all. Good morning, officer.
Good morning, sir.
We do know each other. We've at least exchanged pleasantries a couple of times.
Yes, sir.
In the past. And I guess for purposes of this hearing, would you prefer that I refer to you as lieutenant or officer?
Lieutenant's fine.
Mr. Pryor, I apologize very much for the interruption. I wanted to confirm something on that last exhibit. It was entered by the court. Is that a demonstrative exhibit?
That's what I understood.
Either as a demonstrative or a summary.
Okay, thank you, counsel. Apologies for the interruption.
Judge, I'm also looking for the, oh, I found it. So Lieutenant, you've been involved in a number of aspects in regards to this case, right?
That's correct.
You've done some investigation on your own in terms of welfare check with Lori Vallow, is that right?
Yes.
But you've also interviewed a number of witnesses, is that correct?
Yes.
You interviewed Melanie Gibb, David Warwick, right?
Yes.
Several times?
Few times.
And you've interviewed a number of other witnesses as it relates to this case, is that correct?
Yes.
Okay, now you previously discussed your role as a police officer and investigator in this case. And I guess I want to clarify something if we could, please. As a police officer investigating a case, your role is to conduct an investigation, right? Look at the facts.
Correct.
Try to establish and gain some information, right?
Correct.
But you're not supposed to judge one way or the other, right? You're supposed to remain neutral.
That's correct.
And you're not supposed to narrow that role as a police officer to a particular person. Is that correct?
That's correct.
In other words, you're supposed to look at the evidence as a whole. And rather than focusing on one person and saying, we're going to assume this person did this, and we're going to build our case around prosecuting that person, that would be inappropriate, wouldn't it? Right. Your role is actually to look at all the evidence, consider all the evidence. And once you've gathered all the evidence that you think is relevant to a case, what do you do with that evidence?
We follow the evidence.
Okay, and then once you follow the evidence and you've established a report or you've come to concluding your investigation, what do you do with that evidence that you've concluded with?
We put a case together.
Okay, and then do you provide it to someone?
We provide it to the prosecutors.
Okay, so there's distinct roles as part of a criminal case. You'd agree with that, right?
Yes.
And your role is to conduct an investigation, correct?
Correct.
Look into all possible evidence of any kind, correct?
I don't know why I'm getting buffering.
Correct. And view the evidence, right?
Yes.
Not make any determination as to what that evidence means, but rather gather as much evidence as you think is relevant in your mind and put together a compilation of that evidence, correct?
Correct.
Okay. And then at that point, only at that point, do you provide it to the prosecuting attorney and
Let me just refresh my feed because it keeps buffering. Hold on a moment.
they make a determination as to whether or not they will pursue charges against them. Do you Is it supposed to work?
Yes.
Okay. And if you were not to follow that process, if you were not to follow what I just described, that wouldn't be appropriate. There's protocols. You agree with that, right?
Yes.
Okay. And you should never blend the roles.
You're probably right, Chopper. I don't think it's on
police
the end.
officer
I think it's on the
with the role of a prosecuting attorney. You would agree with that, right?
Explain what you mean by blend the roles.
Well, I mean, it's not a prosecutor's role to show up at an investigation when you're conducting an investigation. And engage in part of the process of interviewing witnesses. You agree with that, right?
I've had prosecutors show up to certain investigations.
Okay, but that's not the norm, is it?
I think it depends on the investigation.
Okay, okay. So in other words, you think that it's appropriate that if a prosecutor is deciding whether to pursue charges against somebody, that they should also participate in the interviewing of these witnesses as part of that process. Is that what you're telling me?
I think it's important for a prosecutor to have all the information.
Well, doesn't that create a problem in your mind?
No, sir.
Okay. Well, let me talk to you a little bit about that. Because if you're doing an investigation and you're really remaining neutral as part of that investigation, right? You're not supposed to make judgments, correct?
Correct.
You're supposed to look at the evidence, gather all the evidence, and then make a determination of what evidence you want to submit to a prosecuting attorney, right?
Correct.
Do you ever get involved in the process of deciding whether someone should be charged or not?
What do you mean by that, sir?
Well, after the evidence is all gathered, and after you've done your report as a police officer and put together all of the information, do you ever go over to the prosecutor's office and say, you know what, I put this evidence together, and you know what, I want to have a discussion with you about whether or not we want to charge this person? That wouldn't be appropriate, would it?
I'm gonna object as argumentative.
Yeah.
It's the same.
Okay.
Why is he being so
So
hostile?
would it be appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses? Would that be proper under any circumstances?
And I'm gonna object as argumentative.
I'll overrule that objection.
And could you repeat the question again?
Yes.
Appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses. Would that be proper under the circumstances?
To interject their personal opinion?
Yeah.
I would say probably not.
Okay. So if you're engaging in name calling or making references to a person's character in a case, that would clearly be an inappropriate act, would it not?
Objection beyond the scope, Your Honor.
That's sustained. And that's facts, not evidence.
Right. Okay. Now, you spoke a little bit about this body cam issue. And you said that it was a policy that there's only one body cam among 7 or 10 of you as detectives. Is that right?
No, sir, I never once said it was policy. I just said there was only one body cam.
Oh, so,
Between 7 detectives.
so in other words, you share a body cam. It's not a policy within the department.
Correct.
Okay, is there a policy in the department about recording or trying to preserve a record when you're interviewing witnesses?
Yes.
Okay, and what's that policy, sir?
When we conduct interviews at the police department.
Yeah.
Those interviews are recorded.
Okay. Now, what about if you're out in the field and you're conducting an interview? Is that to be recorded as well?
There's no policy that says it has to be recorded.
Okay. Do you carry a microphone as well, officer, other than a body cam?
No, not on my person, I don't.
Okay. Do you carry a cell phone while you're doing that? That's issued by the county.
Do I keep the cell phone in my car? Yes.
I didn't ask you that. I said, do you carry a cell phone when you go out in the field?
On my person or in my vehicle?
Either one.
In my vehicle.
Okay. And does that cell phone have the technology that allows you to record or photograph and videotape images?
Yes, it does.
Okay. So what I understand is on November 26, 2019, you were directed your folks to go out to the Lori Vallow residence. Is that right?
That's correct.
Okay, and you said that you were with Ron Ball, is that who you said you were with?
At one time, yes, I was with a couple different officers that day.
Oh, so tell me who you were with on that day. Remind me.
Detective Dave Holt,
Okay,
Detective David Stubbs,
okay.
and Lieutenant Ron Ball.
So there were 4 of you who went out there to locate or to find out some information about what again? Remind me.
About the whereabouts of J.J. Vallow.
Okay, and this was a concern that you had because you were contacted by another law enforcement agency expressing concern about the safety of a young child, right?
No, sir.
Okay, tell me what was the purpose?
It was a simple welfare check.
Okay. And you went out on this welfare check and there were, if my map is correct, please correct me. Did all 4 of you detectives and lieutenants go out at the same time?
No, sir.
You went out at different times.
Myself and Dave Holt went out initially.
Okay, and then when did the other 2 officers show up?
When I called them based on the lies that I had been told.
Okay. And these lies that you've been told, at that point, you and Detective Hope, neither of you decided to bring a video camera, right?
That's correct.
And neither of you decided to wear a recorder to record any of the incidents that took place about these so-called lies, right?
That's correct.
And nobody took out their phone and recorded it or made a video or audio recording of the discussion with Mr. Daybell or Mr. Cox on November 26, 2019, right?
That's correct.
And even after you said these so-called lies, even after you discovered that, Mr. Daybell apparently told you something that you didn't think was true, at that point, did you instruct any of the officers who were coming to aid you? Maybe it's a good idea we should bring an audio with, or a video camera with us, or a mic to record some of these statements, because I have some concerns. Did you think
That's
about
not
that?
information.
We did that, sir.
Hold on.
I'm going with that. There was an objection and sustaining the objection. So, strike the answer. You can ask another question, Mr. Pryor.
Yes, he did, Evil Queen.
And it was Detective Stubbs who had the video cam, is that right?
That's correct, sir.
And that was when you video cammed Miss Vallow, about when you had contact eventually with Miss Vallow, is that what the video camera that you're talking about?
I didn't have contact with Miss Vallow.
Now, I'm a little confused about something. And maybe you can clear this up. You said that you asked Mr. Daybell first about whether he had Lori Vallow's phone number, correct?
No, sir, I didn't contact Mr. Daybell till after I contacted Alex Cox.
Okay. At some point, did you ask for Lori Vallow's phone number from Mr. Daybell?
Yes, I did.
Okay. And at no point did you ever make a threat to him saying you're going to turn this phone number over to us, right?
No, sir.
At no point did any other officer walk up to him and say, if you don't turn this phone number over, you're going to get yourself in a lot of trouble. That never took place to your knowledge, right?
That's correct.
Okay. But then after that, you're saying, at first he said, I'm not going to give you the phone number. And then out of the blue, he decides to give you the phone number.
Objection misstates the facts and evidence.
Okay. Then subsequent to that, he
Hold on,
decides,
Mr. Pryor. When there's an objection, I'm gonna rule on it before you launch into another question. So the objection is sustained.
subsequent to that, he decides to give you the phone number. Is that right?
Can you repeat the question, please?
I'll go back over the analysis here.
Thank you.
Your testimony is that Mr. Daybell refused to give you the phone number at first, correct?
That's correct.
And that was an adamant refusal. He said, no, I don't know what her phone number is, right?
That's correct.
And then without any further prompting by the police officers or any encouragement by law enforcement, he shows back up and gives you the phone number later, right?
Objection is misstating the facts and the
Well,
evidence.
I'm trying to establish the facts, Judge.
The objection's overruled. If the witness has an answer, you may answer.
You say he showed back up. He never left when I originally asked him.
Okay,
I had to ask him twice to get the phone number.
okay. And how much time passed between the first request and the second request?
Roughly a minute.
Okay. So without any prompting by the police, he asked him for the phone number, he denied, and then within 60 seconds, he said, oh, here's the phone number. Is that what your testimony is?
When Detective Hope started walking towards us and I re-asked him again, that's when he gave me the number.
So you had to ask him twice, is that what you're saying?
That's correct.
Now you I'm gonna kind of bounce around a little bit, okay? Please bear with me, okay? You made a comment about supposed paintball guns, and if I misquote your testimony, please correct me, okay? You said something about a supposed paintball gun incident with Tammy Daybell, right?
Yes.
Okay.
Officer Fremont County.
Fremont County.
Did.
Okay. And one of the pieces of evidence is exhibit number 16. Judge, I don't see it going up.
All right, council, if you'd like, we could take a lunch break or we can keep moving on here from that.
Here we are, Judge.
Okay.
Okay, and officer, I'd have you turn to the screen and see if you can read the screen.
Yeah, I
Just
just
read it,
I just switched.
not out loud, just to
Better.
yourself. Let me know when you're done.
I'm done, sir.
Okay. And I would represent to you that this is a email from Tammy Daybell to her friends in the Salem Third Ward of her church. Okay? And would you start with the word something and read the email to me?
Something really weird just happened. I want you to know so you can watch out. I'd gotten home and parked in our front driveway. As I was getting stuff out of the back seat, a guy wearing a ski mask suddenly standing at the back of my car with a paintball gun. He shot at me several times, although I don't think it was loaded. I yelled for Chad and he ran around the back of the house. I have no idea what his motive was, and he never spoke, even after I asked him several times what he though.
Okay, so, and do you see the date on this email? It's
No.
just about friends there.
I'm gonna object to this being characterized as an email.
I'll sustain that.
Okay.
Do you want to clarify, Mr. Farr, what type of communication it is?
Well, it's a communication to the friends of the church, and I think it's a text
I'm
message.
sorry. One second.
I can. I believe it's a text message. Judge, I may have misstated that it was an email.
Okay,
My apologies. So this text message went out to all of the friends of the Salem Third Ward. It's an LDS ward over in the town of Salem, right?
I can't answer
I
that.
don't know. You know where the town of Salem is, right?
I do.
And that's a town that's close to Rexburg?
Correct.
Okay. And obviously you can't answer that about the ward or anything like that, but obviously the term ward would suggest that it's some sort of a religious group of folks they're talking to, right?
Correct.
Okay. But this email doesn't say that she was shot with a gun, or there's even a mention of a gun. The email talks about a paintball.
Again, I'm gonna object to characterization of this as an email. It needs to be
Text message, Judge, it's gonna be.
I'm sorry. Let's be clear.
yeah. When there's an objection, Mr. Farr, again, gotta have time to get it on the record, make a ruling, and then respond, please. So sustained, mistakes, the evidence.
Text.
I'm also gonna object to this being described as a text message. There needs to be some foundation for what this evidence actually is.
Judge, I don't need a foundation. This has been admitted as an exhibit. This is
All right.
it.
I'll overrule that objection. Jury can review it in the format it came in with screen capture.
So anyway, this message from Ms. Daybell to the people in the Third Ward doesn't say that it was a gun, does it?
Says, does say it's a gun, it just says it's a paintball gun.
Oh, it says paintball gun. You're right. Okay.
That's it.
It doesn't say any other gun, though, right? If there's any confusion about that, right?
Not in this email or text.
Okay. Did you also have an occasion to look at the, I'll be bringing that up later, but the the search engine from Tammy Daybell's account?
No, I did not look at the search engine for Tammy's.
Were you aware that, and I'm gonna hack his name, but one of the officers, Officer K, he, whatever his name is, Officer K was provided, email, search information that Tammy Daybell engaged in, regarding paintball guns and a picture.
It's
Are
a
you aware of that?
group post, right?
Objection calls for speculation.
I'm asking whether he's aware of it.
Overruled.
Are you aware of it?
I was aware that he was provided information. I can't tell you exactly what information he was.
Okay, we'll get to that in another day. But did you also listen to the 911 call that was made regarding the paintball incident?
I did.
Okay, and there was no mention of a gun in that 911 call, right?
No,
The mention in the 911 call is that someone took a shot at me or tried to take a shot with a paintball gun, right?
that's correct.
Okay, so the suggestion today that it was a gun is based on your own hunch, right?
No, sir.
Well, do you have the gun?
I have evidence of Google searches done by Alex Cox around that time.
Okay. Do you have information as to where Alex Cox was at the time of this alleged shooting?
Yes, sir.
You do have evidence of that?
He was at the Daybell residence earlier that day.
I didn't ask you on the day of the Daybell residence at the time of this shooting. And do you recall when this shooting took place?
I believe it was maybe 8 in the evening, maybe.
Right. And let's clarify this because the data that you have regarding him being at the residence was much earlier in the day, right?
That's correct.
And you don't have any data that shows that Alex Cox's phone dinged or any other communication device that Alex Cox had was at the location of the house at the time of this paintball incident, do you?
So you trying to
At the time,
defend
no, sir.
Alex Cox?
Okay. And so at this point, the information you're talking about is there's some Google searches by Alex Cox, correct?
That's correct.
And the information is that you've decided to not take into consideration Tammy Daybell's own statement about a paintball gun?
Objection, misstates his testimony.
Sustained. So what other information are you leaning on to suggest that this was anything but a paintball gun?
The Google searches performed by Alex Cox talked about shooting through Dodge Dakota.
Okay. And I appreciate that. And that would be one of Chad and Tammy Daybell's vehicles. Is that correct?
That's correct.
Okay. Were you aware of who was driving the Dodge Dakota at the time that incident took place?
No, sir.
Okay. Did you talk to any of the family members, any of the 4 children about who was actually the driver of this Dodge Dakota that Alex Cox was trying to figure out a way to shoot through?
We attempted to contact those children and they wouldn't speak with us.
Okay, so you don't know whether Chad Daybell or Tammy Daybell were driving that Dodge Dakota, right?
That's correct.
So the reality is that Tammy Daybell was driving the Dodge Dakota. It sounds like Alex Cox had something for Tammy Daybell. Is that what you're suggesting?
I'm not suggesting that. I'm just simply stating what Mr. Cox's Google searches were around the time of that shooting.
Okay, and you're basing those Google searches on your position that you believe this was a shooting, right?
That's correct.
Okay, so if Chad Daybell was driving the Dodge Dakota during this time, and he was the primary driver and maybe the only driver, would that mean then you would be looking at whether Alex Cox was trying to shoot Chad Daybell?
Chad Daybell didn't call in a 911 call and said he was shot at. Tammy Daybell.
Yeah, but Tammy Daybell called in a 911 call about a paintball gun. And it was a paintball gun. And we'll have Officer Cannon talk about that. And we'll listen to the 911 call.
Objection, that's not a question.
Well, the question is,
Mr. Pryor, again,
Right.
you've got to give me an opportunity
Pryor
to roll an
testified.
objection. If it is sustained, this is argument, it's not a question, you can ask another question.
the shooting and the call that's taking place was in reference to a paintball gun incident, wasn't it?
Can you repeat the question, sir? I couldn't hear you.
The call that was made regarding this incident was a 911 call about a paintball incident, wasn't it? They used the words paintball in the 911 call.
That's correct.
We'll move on. Okay. Now, we previously talked about, and Judge, I don't know when you want to stop. I've got a ways to go.
I think this probably is a good time for the lunch break, even though so we will take our lunch recess. That will be an hour. We'll plan on coming back on for additional testimony around 10 and a quarter after 1.
All rise, please.
Yep. The kids never spoke to police. So I found that whole line of questioning from Pryor silly. I agree, Evil Queen. It's going to be long and frustrating. Because Pryor is, I think we can agree, petty. He picks apart all kinds of little things that it's really hard to see whether that they have any bearing on, helping to defend his client. Right? Right. And that's what I was about to say is he keeps harping on, well, she called in about a paintball incident. So first of all, if y'all ever get shot at, don't try to minimize it and say, "Hey, I just got shot out by a paintball." Just say, "Hey, I just got shot at," because then it could be used by the defense attorney later, right? Also, that's my question. Did they find any exploded paintballs so that they could confirm that it was really a paintball incident? But also, how does proving that it was a paintball incident prove that Chad Daybell is not guilty? Right? So, he, Pryor, I've always known he's been this way from the very beginning. Very argumentative, very petty, very whiny. And as Evil Queen and I were discussing in chat earlier, he did try to withdraw from the case last year. And it seemed really like a last-ditch effort to get the death penalty off of the table because he's not death penalty certified. He kept complaining about, having too much evidence to go through, that he was working on this by himself, that he just couldn't do it. He couldn't find any death penalty certified attorneys to assist him. Whine, complain. And he basically put the screws to the judge and said, I'm going to have to withdraw myself from the case at this point. And the judge said, sorry, nope, too late. You can't withdraw from this case. So that's why we're here today. So I think he actually really does care a lot about Chad and this case. And he was just trying to do a maneuver at that point. And that's what happened there. Pryor not shutting up when there's an objection really shows a lack of respect of the court. Right. And, he's been practicing for a long time. So he should understand how to do that. And it shows that he doesn't have impulse control. because it should be part of your muscle memory. It should be, if you've been a lawyer for that long and if you have a lot of trial practice, it should be part of your muscle memory to hear objection and just shut up and listen for the court to rule, right? But he doesn't. He just keeps going, and he also gets argumentative, and he testifies on behalf of his client. And
And welcome back to Law and Crime, everybody. Thanks for joining us. So we are still in the Idaho trial for defendant Chad Daybell.
So I'm going to switch back over to the Crumbly sentencing because I want to hear what happened there. Hear it with you all.
I have now, my answer will be drastically different. If I even thought my son would be capable of crimes like these, things would have absolutely been different. Even worse.
So what she just got done saying is that, she was surprised at how people responded to her saying that she wouldn't do anything different. So she's coming back around and justifying the fact that she said that she wouldn't have done anything different. At this point in an argument, you need to just let it go and stop trying to over-explain yourself and realize that it was a terrible, tone-deaf thing to say, but also the wrong way to think in a case like this. Yep, I agree. Walk away. Yep, I agreed with you too, Lollipop. So anyway, this way of thinking is, she's trying to convince everybody to still think the way she thinks. That's what this says to me. She clearly still has not accepted her responsibility in this situation. Still needs to convince people that she didn't do anything wrong, and even the way she thinks about it isn't wrong. So she still has to convince people that when she said something that stupid on the stand, that there wasn't anything wrong with her saying that. And so she's really, really stuck on, the perception and rather than understanding a mistake she made and trying to process it and assimilate it and then recover from it and rehabilitate from it, she actually is trying to convince people why she's right.
When I learned during the police investigation that he had been planning a school shooting before November 30th. He was not the son I woke up. He was not the son I knew when I woke up on November 30th. The Ethan I knew was a good, quiet kid. He loved his pets, family vacations. My husband and I used to say we had the perfect kid. I truly believed that. And that's who I saw and thought I knew.
So let that be a warning to all parents everywhere. Just because you think you have the perfect kid, if you think you have the perfect kid because you're ignoring all the things that he's been saying to you about how he feels, you may not have the perfect kid. Okay? Just letting you know.
As the details started emerging during discovery, I was horrified to learn concerning behaviors my son was reported doing at school. Refusing to take a makeup test he told us he took. Sleeping in class. Drawing pictures of guns on his assignments. Writing, quote, "My family is a mistake." Watching a video in class of a mass shooting that fatal day, along with internal communications that took place between his teachers and counselor, Mr. Hopkins. That he is, quote, "on my radar," and, quote, "he seems to be having a rough time," was never disclosed to us. his parents. The school claimed this was not abnormal behavior because of the pandemic and Oxford being a quote gun community. To say I was curious to learn this information is an understatement. This is not normal behavior to us and very different.
So here she is. It's the school's fault. It's the school's fault.
Than what Ethan led us to believe was happening at school. Not only were you left in the dark about previous concerning behavior, but in the counselor's office that morning, none of those previous issues were brought to our attention. I can't stop thinking, had they have been, the conversation that morning would have been much different.
I don't think it would have been, to be honest with you. I don't think it would have been much different because she still continues to excuse her own behavior. And also, I read somewhere where in her sentencing, she requested to be able to live with her. She requested to be able to live with her lawyer, the lady sitting right there to her left, our right, Shannon Smith, the one who started out her opening statements by quoting Taylor Swift.
That we would have taken a deep dive into what's really been going on with my son. I wonder if Hopkins and EJAC have those same regrets too. Instead, we were led to believe, not only from Hopkins and EJAC, but from Ethan as well, that this was an isolated event. We felt confident in trusting the professional's advice to let him stay in school that day. Quote, he does not pose a threat to himself or others. It was suggested that him being around peers would probably be good. We agreed. We were never asked to take him home that day. If that was discussed as the best course of action, we would have obliged. The prosecution keeps saying we didn't give them the big picture that morning at the counselor's office. But what they failed to acknowledge is the bigger picture the school did not give us. I'm not the same person I was prior to November 30th, 2021. This tragedy has changed who I am and has taught me some very valuable lessons. It said in suffering, we gain wisdom. I've also gained God. In the quiet hours of myself, I prayed to him about the deep impact this tragedy has had on the families and the endless pain no one should ever have to feel. For it is God who holds a true understanding of our pain. I've also learned to depend on him for peace and strength. Alone, I'm not strong enough. I've learned that we cannot tell or predict what will happen to us in this life. One day you wake up and everything can change. We can, however, decide what happens in us, how we take it, what we do with it. And that's what really matters in the end. That's the test of living, is how we take the unimaginable, the tragedies, the raw hardships, and make them a thing of worth and beauty. I've also learned to never think this could not happen to you, and stereotype that bad kids come from bad parents. The prosecution has tried to mold us into the type of parents society wants to believe are so horrible, only a school or mass shooter could be bred from. This is a very real assumption to have. We were good parents. We were the average family. We weren't perfect, but we loved our son and each other tremendously.
I'm sorry. I'm sorry. You can keep telling yourself that you are good parents, but that is how we got to this place. You kept telling yourself that you were good parents. And then your kid went and killed other children, okay? That's not the result of good parenting.
Everything we strived for was to make sure our son had the best life we could give him, to grow up with traditions and experiences we had, to be the best.
Let me make this crystal clear. Good parenting does not merely constitute giving your child material comfort. Okay? I want to make that crystal clear. Your child needs to understand how to live and cope in the world, how to be self-sustaining, how to be self-motivated and have self-worth, and to be able to carry themselves and to have self-worth and well-being that they can achieve on their own without the help of external devices like drugs and alcohol. That's what good parenting is getting a kid to a place where they can lead a life like that. It's not good parenting just to give them shelter and food and send them on their way. I'm just letting you know, all right?
Best person he could be. I know we did our best. The love I have for our son, mixed with regret for not seeing what was ahead, weighs heavily on me. My point is, this could be any parent up here in my shoes. Ethan could be your child, could be your grandchild.
That was their defense. That was the entire crux of their defense. This could be you. This could be any of you. Nope, it couldn't. And the jury disagreed because they were neglectful.
Your niece, your nephew, your brother, your sister. Your child can make a fatal decision, not just with the gun, but a knife, a vehicle, intentionally or unintentionally. If there's anything the general public can take away from this, is that this could happen to you too. The tragedy has taught me the true meaning of unconditional love as I watch my parents still love and care for me wholeheartedly, no matter what has happened. If there's nothing else I can do right in life, I do still love my son unconditionally, and perhaps that is my purpose. Your Honor, I don't envy the decision we have to make today. I understand this is a novel case, and punishment expectations are high, not just from the prosecution, but from all those affected as well. The heartbreaking journey these families have endured. Hang on, I have to back up. I missed my most important. I need to cross.
Oh God.
The most valuable piece of wisdom I gained is the power of forgiveness. To forgive the prosecution for the slander and hate against me and my husband.
Oh my God.
Ms. McDonald, Mr. Keys, I have hated you with deep anger, but hate is too heavy of a cross to carry.
This is
I
the
need to
most
be set free of
important
that
part.
burden and recognize that you are people just like me, imperfect.
So the most important part is for her to make sure that she tells the prosecution that at times she has hated them, but she forgives them. And let me just remind you that James Crumbly made threats on Karen McDonald, the prosecutor, in jail calls, like the brilliant masterminder, the brilliant scholar that he is.
The child of God. I know he wants good things to happen to you, and in any conflict, whatever the circumstances, he is there loving both sides. To the victims and the families. I stand today not to ask for your forgiveness, as I know it may be beyond reach, but to express my sincerest apologies for the.
She can't even she can't even be truthful in her own statement. She says she stands here today, but she's sitting there. She could at least stand while she's saying that. I'm being petty now, but still.
Pain that has been caused. Your Honor, I don't envy you in the decision you have to make today. I understand the punishment expectations are high from all sides. This heartbreaking journey families have endured is more than anyone should have to bear and acknowledge in its full depth. My time in confinement has been filled with deep remorse, regret, and grief over this tragedy. I have taken this one day at a time, trying to survive, navigate, and cope with the endless heartache, pain, and grief I feel for the families of Hannah, Justin, Madison, and Tate. I have also lost myself over my son's wrongdoing. I've been shredded by in me, shamed as a horrible parent, pained to be a terrible person. but the worst how it carries my own self-judgment, remorse, and deep regret. I've been criticized, I don't show emotion, I'm unsympathetic, I don't cry enough, but alone I grieve. And if you were to look into me internally, you'd find I've died on the inside. I will be in my own internal prison for the rest of my life. Your Honor, I ask you to take consideration that I have been locked in a cell 23 hours a day, essentially in solitary confinement for over 28 months, and that the court finds a fair and just sentence for me.
Thank you.
Yes, sure, thank you. Your Honor, as I pointed out in my sentencing memo, this was a no-win case. When we walked in the door, there are no winners here, every single person was one loser.
Agreed.
And there's also no limit on the amount of sadness, grief, and horrific emotions that are felt across the board in this case. And when Mrs. Crumbly does express remorse, when she expresses sadness, there's a tendency, and there has been a tendency for people to say she's shifting from sadness to the victims and putting it on herself. She's not doing that. There's an abundance of sadness. There's enough sadness to go around for all of the victims, for Mrs. Crumbly, for everyone involved in this case. And that the victims have come in and obviously want the maximum sentence. There has been a narrative throughout this case that they believe is true. And this court knows that there is other information that was not a part of this case. And I believe this court knows the defense was hugely hamstrung, and I think the court was pained at times over what to do. I'm talking about not being able to call the medical professionals, not being able to call the shooter to the stand, not being able to cross-examine on various pieces of evidence.
I'm not convinced the shooter would have helped you.
Right, all of those are obviously issues, but there were things that hamstrung the defense. And I do believe
the forensic records.
I do believe the shooter would have helped, and I do believe the forensic records would have helped.
More
and I understand the court has already ruled on that. I understand that. I think the tendency, though, after hearing the narrative that has been made public, has been to make Jennifer Crumbly sound like a monster, to vilify her, to make her sound like a horrible mother, an evil person. And the truth is, it's an effort to put her in a category of other, to say this is not something that could happen to any of us. And it is. It is something that could happen to any of us. And people fail to realize what the sentencing memo shows the court through numerous letters of support, that Mrs. Crumbly does have a kind heart. She does have compassion. She has spent night after night crying, not for only herself and her son, but also for the victims and for what her son did and what she will live with, knowing he did, and what she missed all the years forward. At the end of the day, we asked the court to look at Mrs. Crumbly's role in the offenses. We asked the court to consider that while she did not oppose having a gun in the home, she was not the person who was responsible for storing the gun and believed it was being stored properly and that it was locked. Mrs. Crumbly obviously testified, and all of the evidence at trial showed she believed there was a string lock, a cable lock placed on the gun, on the weapon.
You know, I don't mean to interrupt you, but that has really troubled me from your sentencing memo, because you spent a lot of time talking about the fact that she didn't know anything about the gun. She didn't lock it, she wasn't responsible for it. But at one time, she was texting her husband to see whether or not he got the gun and how much it was. She posted pictures of it as her son's Christmas present. She shot the gun. And I don't know if you're aware of this, I don't know if either side was aware of this, but the first jury determined that there was a claim that the gun was the responsibility solely
of defendant James Crumley. And Mrs. Crumley testified that when she returned from the range with the shooter on November 27, it was the defendant James Crumley who was responsible for the 6-hour retrieve from the car and was supposed to keep it safe. The first jury recognized that the GPS admitted in the case shows that even prior to the defendant James Crumley returning to the house, the shooter was videotaping the unlocked 6-hour in the kitchen of the home. So that's not true. That's not true. She also testified that a key to the cable lock was kept in the beer stein in the kitchen, but it's clear that the cable lock was clearly never opened.
Your Honor, first of all, the jury's finding about the timing of the GPS and when the gun video was made is not correct. The evidence at trial did not support that. We know that's not correct. Mrs. Crumley left the gun in the car so that James Crumley could put the gun in the house and store it correctly. Mrs. Crumley, there were multiple cable locks in that house because there was more than one cable lock. There was not just the cable lock that was on the 6-hour. There was more than one.
I didn't recall that.
There were not more than one found, but whatever Ethan Crumley did with the cable lock from the 6-hour, we don't know.
The gun wasn't locked.
Your Honor, factually, during Mrs. Crumley's trial, it was not proven that the gun was not locked. I don't know what happened.
It's like they're retrying the case here. My God. They've been convicted, and the judge is like, dude, the gun wasn't locked.
James Crumley's trial.
You know about his statements. The gun was never locked.
Whose statements?
Mr. Crumley's statements.
Mr. Crumley and Mrs. Crumley talked about how the gun had been locked.
Ethan Crumley said it wasn't
In
locked.
all the evidence I saw. Well, Your Honor, obviously we have factual disputes.
Go on. I don't think the evidence has shown that she had no involvement with the gun.
I'm not saying no involved. I said she supported the gun. She didn't object to the gun. But when it came down to it, probation writes in her narrative that she taught her son how to use the gun. And it's very obvious watching the evidence in the trial that she was not the one teaching him how to use the gun.
There's no evidence that she taught him how to use the gun.
When Mrs. Crumley spoke, she
That's funny, Kaigi girl.
acknowledged what the testimony was at trial about all of the different things that she wished had come to her attention from the school employees. And the prosecutor's office has said that the proposal the defense has made regarding Mrs. Crumley is a slap in the face. And what's truly a slap in the face, not only to the victims in this case, but also to the Crumbleys, is how much the Oxford schools did fail the Crumbleys and all the victims. Because if Mrs. Crumley had been presented any of those 5 things, things would be different and we would probably not be here today. I am asking this court, I know the court of public opinion is running high right now. Emotions are running very high. There are many, many complicated issues with this case. It is a dynamic and different case than most cases. Mrs. Crumley does have a good heart. This is a woman who had no felony history. This is a working mom who was very busy, did have a hobby.
I don't think there's anything wrong with these things.
I'm just saying, largely the evidence at trial were some of those things. And Mrs. Crumley did have an enormous amount of love for her son, and what she has been painted out to be in the media and throughout this case, and even throughout the victim impact statements today, is just not congruent with the people who know Mrs. Crumley and know her heart. It's also not congruent with the text messages she sent right after the shooting about how she wished she would have died instead of one of the kids.
I don't think the verdict was about how feeling she is or how sad she is. I think the verdict was about behaviors that led up to that day.
Well, there has been an enormous amount of criticism about whether or not she said enough, and there was cross-examination extensively about whether she cried or not enough on the stand, or when during the videos that were played of police interviews and things like that. And then, on the same hand, when
I
this
don't
is,
doubt that they were both in shock. I don't doubt that.
and at the end of the day, though, when she did cry, there was an objection about crying. And so Mrs. Crumbly from the very beginning has been damned no matter what way she went. This was the most horrific thing that could have happened to the community, to the victims, to these families.
Attorney cry.
Absolutely horrific. At the end of the day, however, it's a unique and complicated case, and that is why I proposed the sentence I did. I don't believe the sentencing guidelines take into account the very unique situation that we have in this case with a young man who will be in prison forever. I'm asking the court to keep that in mind, and please keep in mind the other arguments throughout the memo.
I think you know that I read everything you send in.
I do, and I appreciate that, thank you.
Do you want to sign now, or do you want to put the counter for the signing first?
I prefer just to be able to respond once, Your Honor.
Are you okay with that?
That's fine, Your Honor.
All right, would you like to address the court, or would you like a client to address the court first?
Would you like to address the court, James?
I would.
Yes, Your Honor. Mr. Crumbly will address the court. For the record, he does have something typed out that I typed out for him, so it's bigger, it's easier for him to read, Your Honor. You can't.
Here we go.
No, she said she cannot tell them to.
Let's that.
He would, Your Honor, there was some confusion about whether or not he could get his second handcuff off. I was just clarifying, the court said she cannot tell the
I
sheriff's
would
office.
just, but does he have to keep that handcuff on?
Yes. I was just clarifying, Your Honor, thank you.
Before I address this court directly, I want to do something that I have never been able to do throughout this time until now. I want to say I can't imagine the pain and agony that for the families that have lost their children and what they're experiencing and what they're going through. As a parent, our biggest fear is losing our child or our children. And to lose a child is unimaginable. My heart is really broken for everybody involved. I understand my words are not going to bring any comfort. I understand that they're not going to relieve any pain. And quite frankly, they probably just don't believe me. However, I really want the families of Madison Baldwin, Hannah St. Juliana, Tate Meyer, Mir, and Justin Schilling to know how truly sorry I am and how devastated I was when I heard what happened to them. I have cried for you and the loss of your children more times than I can count.
I actually believe him when he says this. And yes, and he's actually standing to say this, which shows much more respect than Jennifer did. I feel like he's always shown more respect, but again, he threatened the prosecutor in jail calls. So he's maybe just a tad bit better.
I know your pain and loss will never go away. Part of you will be missing forever. But please know that I am truly very sorry. I am sorry for your loss as a result of what my son did. I cannot express how much I wish that I had known what was going on with him or what was going to happen. Because I absolutely would have done a lot of things differently.
That's interesting. I wonder if he look at Jennifer looking at him after he says that. So she made a point to make it clear why she said she wouldn't do things differently. He has now made it a point to say, I would do things differently. And she's like, what'd you just say? You just make me look bad. Well, good. I'm glad he said that because it was wrong of her to say that. So, haha, Jennifer.
Again, my heart pours out to every single one of you. It really does. Judge Matthews, I'm not gonna overdo a lot of things that were already said. But I know the full amount of pressure that you have on you and the responsibility that has been placed on you throughout this case. I have the utmost respect for you, and I'm simply going to ask that you sentence me in a fair and just way. You presided over my trial and heard the evidence that was presented against me. You know that what my son did, I was not aware of, or that he was planning it, or that he obtained access to the firearms in my house. There was absolutely no evidence that suggested that. As my attorney has told you, I've been on lockdown for 23 hours a day. I've not been able to speak to my son since November 30th, and I have not been able to speak with my wife since December 3rd. I know that I have experienced pales in compassion to what those families who've lost their children and countless other victims experience every day because of what my son did. But I want you to know I too grieve for everyone, as I have explained. For everyone that's been affected by what my son pled guilty to doing. And I'll continue to feel this pain for the rest of my life as well. If I could go back and change things, if I could go back and do things differently, and maybe none of us would be here today. So again, I ask Your Honor to impose a just and fair sentence based on the truth about what you heard during my trial. I'm asking the court to sentence me to time served and place me on probation for the maximum time allowed with the GPS tether for as long as the court deems necessary. I also want to address one last thing. And that's to what Tate Miu's dad said. It is time that we all know the truth. We have been prohibited from telling the whole truth. The whole truth has not been told. And I'm with you, Mr. Miu. I too want the truth. Because you have not had it. You have not had the truth at all. The truth has not been presented to you. Thank you.
I'm assuming that's about the school.
Are you wanting to? Go ahead.
Your Honor.
Same.
Thank you, Your Honor. I did submit a sentencing memorandum, Your Honor. I'm not going to belabor the points that I made in my memorandum, as I do believe that it was thorough. However, I do want to note for the court that, especially in statements that have been made about James, that he lacks remorse, that he doesn't feel bad, that he's trying to put off responsibility on everyone but himself, that he's allegedly made threats toward the elected prosecutor. Your Honor, in some of the same calls that the prosecution has tried to use and has quoted in their own sentencing memorandum and attached as exhibits to their memorandum, as I noted in my sentencing memorandum, Your Honor, James also said in those very same calls that he wished that he had known what his son was capable of. That if he had known, if he had been made aware of these things, if he had known that his son had obtained access to a firearm, that maybe he could have saved the poor children's lives. That maybe he could have saved a lot more than that. Your Honor, there has never been a time that James Crumbley has not acknowledged what happened in this case. He has felt horrific grief for not only the families, but for the people who have been affected. He's grieved for himself, for his own child. And while that may not be something that is a popular statement to make, he's grieved for the child that he believed he had. Not the child who pled guilty, but the child that he believed he had on the morning of November 30th when he dropped his son off at school. James could not have predicted what his son was going to do that day. He couldn't have predicted because he didn't know that it was going to happen.
That's the problem.
As James said, Your Honor, you sat through the trial, Judge. You heard the evidence that was presented. You also know that there was no indication given in the evidence presented that James had knowledge of what his son was planning. That James didn't know that his son had been accessing that firearm unsupervised, or that he had access to the firearm unsupervised. Judge, you heard that that firearm was stored legally at the laws at the time in November of 2021. That there may be differing opinions on whether or not that firearm was stored responsibly, Your Honor, but it was stored legally. It was stored unloaded. It was stored with the ammunition stored separately. Your Honor, James Crumbley did and made the decisions that he thought, based on the information that he had, even on the morning of November 30th at the school. You've heard multiple times that James had no knowledge of what his son was intending to do later that day. That even the school officials, the people who were trained, they talked about the special training that they had during trial. Even those individuals said that they did not believe that James's son was a threat to other people. That they had concerns about his sadness, Your Honor.
They had at a minimum concerns about his danger to himself, right?
Correct, Your Honor. Danger to himself due to his level of sadness, that they wanted him to go talk with somebody, but that it wasn't so emergent that he needed to be removed immediately.
And isn't it the reason they didn't want him to go home?
Your Honor, there's some dispute as to whether or not the testimony from the school is accurate as to what actually occurred in that office. And Judge, I don't want to try and retry the case. I don't think it serves anyone or benefits anyone. But I do want this court to be aware, and Your Honor, you observed James during the trial. You're aware that he had difficulties throughout the trial. He showed emotion. He struggled with some of the things that he heard and saw. And
I don't know how anyone could know.
I agree, Your Honor. I agree. And as I've acknowledged numerous times throughout this case and throughout the trial, it is an incredibly emotional trial. Today is incredibly emotional for everyone involved. I echo what Ms. Smith said. There are no winners here. Everyone has lost in this case.
I think that Ms. Smith said in her sentencing memo that it's possible to be sad for everyone here, not just the victims, but their families as well. It's possible to be sad for everyone.
And I agree with that, Your Honor. I did ask the court to sentence James to time served. I am going to echo his request for a period of supervision with a GPS tether. I understand that the court, we did object to some scoring. I understand that, again, the court has significantly strong pressure. The emotions run high in this case, Your Honor. I don't envy what you have to do. However, I am asking that you consider my request. Thank you, Your Honor.
I just have to correct some facts. The allegations that Jennifer and James Crumbley were left in the dark just are not true, and the evidence at trial does not show that. The evidence presented at trial that as late back as March, the 9th, 17th, and the 20th text messages about from their son to Jennifer Crumbley, that he was seeing things. In April, his text messages to his friends indicate he asked for help. His mother laughed at him. April 26th, Jennifer told his friend's mother that he was depressed. There were multiple visits to the gun range. There was 2 guns purchased for him. The Crumbleys were aware that he was struggling in school, and in fact, they had a rather, I would say, critical fight the night before, which is all detailed, incidentally, and as well as where the gun actually was in the shooter's statements, his plea, and the multiple statements he made to the psychiatrist, the very same things. They stand here and say, "Oh, if only we could have called them." Well, calling those individuals would have resulted in all of the claims that's inconsistent with what he said, and it's inconsistent with what the psychiatrist testified to in the Miller hearing. So I had no intention of addressing this, but it was brought up, so I feel as if I have to, and I have a duty to do so. They were concerned. The evidence showed that. They were very concerned. They were concerned about the drawing, and they were concerned based on the fact that they were called to school. Jennifer Crumbley's own statements acknowledges she was called to the school. They wanted him to get help. She said she had to go back to work, but they said that he could stay. None of that, by the way, is in dispute, and that she left. This insinuation that if only I had known he was sleeping in class and teachers might have been concerned, then none of this would have happened, is at the core of why we saw 6 people standing here and saying there's no remorse or accountability. And I want to be clear, remorse does not sound like I feel really bad. I'm sure they do. I don't dispute they feel bad. I don't dispute they have grief. That's not the kind of remorse and accountability these victims are looking for. What that looks like is we messed up. We should have done this and we didn't, and we are very sorry. And that has not happened, which is what we're talking about here and what you heard the victims say. I don't want to belabor any more that we had to in the trial. I have a deep respect for Ms. Lehman, but the facts of this and the elements of this case simply are not that the prosecution had to show that he had actual knowledge and he could predict and he knew exactly what his son was going to do. Those are not the elements of the crime. It's not what the jury was required to find, and it has nothing to do with their actual conviction. Jennifer Crumbley and James Crumbley were not convicted based on a narrative. They were not convicted because somebody thought they were a bad or good parent. Those 2 trials involved multiple motions and objections over evidence that the court sustained. We did not allow the jury to present the information about Jennifer Crumbley that her lawyer made a strategic decision to in the middle of the trial, say, open the door, you can bring it all in, was not due to the prosecution's requests or actions. But you can't seek to exclude evidence and then allow somebody to testify to an inconsistent with the evidence. The last thing I want to say is there is case law that the court's aware of about what the court can consider in fashioning a proportional sentence. And we don't give power or authority to victims to decide or render verdicts, with good reason. But we should not, and we cannot, sanitize their pain or the weight of the impact or chalk it up to it's emotionally charged, as if everything that's happened here is because people sitting here are too emotional and they pressure people, because that just simply isn't true. And not only should you consider the weight and the impact of the defendant's actions and inactions, you are required to, pursuant to the case law. It is one of the factors to consider, the severity and the impact of the crime. We've heard a lot about it's not what happened in the school. And while I understand that the negligence, the gross negligence that occurred happened before what happened in that day when he left that bathroom and started firing the 9mm and killing 4 kids. I understand that, but it is absolutely about what James and Jennifer did and what they didn't do, and the gross negligence that caused those acts. This is what it looks like. This is what it looks like. When 2 parents have the ability and are in the best position, they do both, they vigorously,
I wonder to myself, I was looking straight on at Mr. St. Juliana, whether or not he'll ever smile again. And that's very difficult. I'm very aware of my job in this situation, very aware of my job, to not be swayed by public opinion, by media, by any of those different things. I can't and will not pretend to understand the pain the families are experiencing, but I did sit through these trials with you. I saw what you saw, I heard what you heard, so I can and will offer my deepest and most sincere condolences for your unfathomable losses. It's as I just said, it's not my role, it's not the role of the court system to make an example of the defendants. However, it is a goal of sentencing to act as a deterrent. These charges are not jury edicts about gun ownership or keeping a gun in a private home. All of the jurors in both trials agreed that they understood that. Parenting is a complex job. Parenting practices around the world share the goals of ensuring health and safety, preparation for life as a productive adult, and transmission of cultural values. Parents are not expected to be psychic. But these convictions are not about poor parenting. These convictions confirm repeated acts or lack of acts that could have halted an oncoming runaway train. About repeatedly ignoring things that would make a reasonable person feel the hair on the back of their neck stand up. Opportunity knocked over and over again, louder and louder, and was ignored. No one answered, and these 2 people should have and sure didn't. Mr. Crumley, it's clear to this court that because of you, there was unfettered access to a gun or guns, as well as ammunition in your home. You characterized yourself as a martyr and threatened the well-being of the prosecutor. Mrs. Crumley, you glorified the use and possession of these weapons. Your attitude toward your son and his behaviors was dispassionate and apathetic. Your response to school staff after a 12-minute meeting was, "Are we done here?" During your trial, you announced that you wouldn't do anything different. I understand that might have been misinterpreted, but it did cut the victims deep. Because of both of your actions and inaction, among many, many other things, the world is missing out on a top college university will miss out on Tate's star quality football skills. I met Raina, who's wise beyond her years, and she's told us that among many, many other things, community will be denied Hannah's kindness, creativity, and sense of humor. Among many, many other things, the world will miss is Madison's kind and loving soul, and the light that reflected her beauty both inside and out. Although a hero in death because of his organ donations that helped so many, we will never know where Justin, an excellent student with vast skills and interests, described as a mentor and a leader, would have left his giant imprint. The impact statements given here and the written statements provided to the court describe the cataclysmic impact the deaths of these children have had on their children. With regard to each defendant, this court has spent night and day thinking about this case, as you can imagine. I've prayed about this case, I've thought about this case, and I've considered the possibility for rehabilitation, the need to protect society, the penalty appropriate to the conduct and goal of deterring others from similar conduct. I have reviewed the pre-sentence investigation reports. I am, of course, sadly familiar with the facts and circumstances of these cases, as well as those surrounding each defendant. The advisory sentencing guidelines in this matter do not capture the catastrophic impact of the acts or inaction in these matters. The guidelines do not take into account the complete lack of insight both defendants have for their behavior to this very day. The guidelines do not account for the severity of the circumstances in this matter. The guidelines ignore the survivors, including shooting victims Phoebe Arthur, Elijah Mueller, Riley Franz, Kylie Osage, John Asciutto, Molly Darnell, and Aiden Watson. They were deeply wounded, both physically and emotionally. In addition to the 7 wounded, each of the defendants' gross negligence has caused unimaginable suffering to hundreds of others as a result of what happened that day. Each act or inaction created a ripple effect. Therefore, an out-of-guidelines sentence is appropriate and proportional. The court uses the useful tool of the legislative guidelines, which embody the principles of proportionality, while also taking into account the nature of the offense and the background of each defendant. I believe that the following sentences would be in the best interest of justice and are reasonable and proportionate to the seriousness of the matter and the circumstances surrounding each defendant. With regard to Jennifer Crumley, it is the sentence of this court, Ms. Crumley, that you serve 10 to 15 years with the Michigan Department of Corrections. You will have credit for 858 days. State costs are $272. There's a crime victims' rights fee of $130. You and your agents may not have any contact with the families of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. I will issue another ruling with regard to contact with your son, the shooter. Excuse me. As to defendant James Crumley, it is the sentence of this court that you serve 10 to 15 years with the Michigan Department of Corrections, that you receive credit for 858 days, that you pay state costs in the matter of $272, that there is a crime victims' rights fee of $130, that you or your agents have no contact with the families of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. Ms. Wheeler, have I left anything out with regard to sentencing? No restitution has been requested by any of the families at this time, correct?
That's correct.
Thank you. I would like to advise both defendants that you are entitled to appellate review of your conviction and sentence, including that the sentence exceeds the guideline range. This is done by filing a claim of appeal by right, or when you are not entitled to file a claim of appeal by right, an application for leave to appeal. If you cannot afford to hire an attorney to represent you on appeal and you request an attorney may be appointed for you. You may by completing the request for appointment of attorney section of the form that will be provided for you and by returning the form to this court or to the Michigan Assigned Counsel System at the address on the form. If you wish to preserve your automatic right to submit the form received,
Okay. I just wanted to see. I had heard that the judge had harsh words for the Crumbleys. In all honesty, they weren't harsh enough for me. I'm gonna be honest with you. They weren't harsh enough for me. But she's always been a super reserved, kind of conservative judge. It's not that I don't judge her for it. I'm not judging the judge for it. I just it would have been satisfying to hear a little bit more uh judginess from her to them. Make sense? All right. I want to now that they are not back yet from lunch. They should be back soon. But I do want to look at Hidden True Crime. I think her name is Lauren. Yeah. Did a lunch update. I want to see if she gives any interesting information from inside the
trial, day 2, and there's a lot going on. So first off, the day starts off very, very, very heavy. Autopsy photos of JJ and when their bodies were discovered, not autopsy photos of the time where their bodies were discovered. Yes, maybe some autopsy photos of JJ too were shown to the jurors today. So the jurors have, they have computer screens set up. There's like 3 jurors per computer screen to look at the photos. Vicky and Kay Woodcock are not here. They clearly got word that it was going to be a very, very difficult morning. They did not show the gallery, the photos this year. I saw the photos last year at Lori's trial. You can't unsee them. I'll never forget them. I know exactly what they were looking at. The descriptions were just enough to understand when they talked about the duct tape over JJ's mouth. JJ, we will never forget you. And that's why we're all here. Tylee, we'll never forget you. We'll never forget that green bucket. It's just, you can't, I can't imagine what the jurors were seeing. It's day 2 of this trial. They still don't understand the case, and this is what they're seeing. Larry Woodcock was wearing his sunglasses, and you could hear him breathing heavily. And it was very, very heavy. I'm grateful that I wasn't able to see those. I didn't need to see those photos again, but what I was able to do, I have a great seat. And what I was able to do was see Chad clearly and all the jurors clearly. And I, because it's live streamed this year, unlike Lori Vallow's trial last year, I was able to just simply be eyes. I paid very close attention to everything going on. And this is what I saw. The jurors were paying attention, so much so that as prosecutor Rob Wood talked, they looked at Rob Wood. And when Rob Wood finished his sentence, every face turned to Detective Ray Hermosillo, who was the witness uncovering the children's bodies. So they would go like this, and all 18 jurors would then turn and look this way and then this way. They were being so attentive. They were listening to every word. And 3, if not 4 jurors were crying, very wiping tears away, very clearly wiping tears away. There might have been a 4th that looked like they were crying as well. A lot of emotions from the jurors. 2 women and 1 man that they were very clearly crying. In addition to tears by the jurors, again, you could also hear Larry Woodcock, and there were people comforting one another. I'm glad I didn't have to see those photos again, but I know what the jurors are seeing, and it is the worst you could imagine. The worst. Chad Daybell showed emotion. Well, I don't know, micro emotion. That's how one person put it. Like, this is what Chad Daybell did during this time. He was slouching. He would shake his head. His, he has this kind of like straight, like mouth. There's my best impression. It got a little bit deeper, a little bit more like that, and then he was going like, he was shaking his head. Like, take that for what it is. I'm not the psychologist, but I'll ask John when I show him my expression. Chad definitely looked at me several times, and I looked at him. Yeah, I was in an easy place to be seen. But I do realize that Chad probably does know who I am, and he has been told by John Pryor, because I think it's important to point out that I and John and I are the ones that interviewed his sister-in-law, Heather Daybell, a 3-part interview. That's a very important interview. Heather Daybell has been subpoenaed by John Pryor. Chad Daybell refers to Heather Daybell as his dark sister-in-law. That has caused a lot of this.
I don't know if you saw that interview with Heather Daybell, but it was a good interview. It's always interesting to see. That's for sure. Walk away, Renee. I liked when she did that impression of him, his frown getting a little deeper. But it's always interesting to see when a family member that doesn't agree with with that family member who's being accused comes out and talks about it. And Chad's family, by and large, has stood by him, but there are a few standouts. And if you can include Tammy's family as part of Chad's family, there have been some people from Tammy's family who have come out and spoken against him. Chud Dumbleland, Patricia. Yeah, her husband is definitely a legit forensic psychologist, part of her channel. It's a good channel. It's called Hidden True Crime. And they've been heavy on top of this case from the very, very, very beginning. I think they were pretty heavy on the Suzanne Morphew case as well, if I recall correctly, but I could be wrong about that. Great channel.
And interestingly enough, just by coincidence, Heather Daybell's daughter is married to Detective Hope's son, and Hope keeps coming up. And I am going to suspect that John Pryor might try to cause a connection between those two things. Thank you, Amanda, for becoming a member. But I don't know. But so Chad does definitely look over. We make eye contact. Nothing beyond that. But I do think that Chad likely knows me probably as the podcaster people that interviewed his sister-in-law that is dark. So it would make sense if he's been told that. So after this, so we have a recess after that really, really difficult moment in court. We go back in, we take a breather, and Detective Ray Hermosillo continues. I do have another live, by the way, that I'm going to be doing at lunch today. After this, I'm going to head over to Fox 10 with Justin Lump, and we're going to talk a little bit. So let me just tell you some things that are really important, and then later today I will also go live a little bit longer. There are 3 Lori Vallow Daybell jurors in court today too, watching jurors from the last trial. I want to say one of the jurors, the youngest juror from Lori's trial, is here. She was 20 years old, 20, when she was a juror on Lori's trial. She does not yet want to go public, maybe won't ever want to go public, but she is now here again in solidarity after what she saw and witnessed. And so you can just, again, only imagine what all of these jurors are seeing, a grown man in tears in the jury box today. Let's talk John Pryor's cross-exam. The Judge Boyce has had to correct John Pryor 3 times that once an objection is made, he can't continue to be argumentative. He has to wait for the judge to make a ruling on the objection. He is feisty when he is cross-examining. But one thing that I'm really noticing is Chad Daybell is a sloucher. Chad absolutely slouches. I've seen him every direction. He slouches. So do I. I'm not even making fun of Chad Daybell by saying that. It is what it is. The guy slouches big time, bigly. I have never seen Chad Daybell stand up so tall as when John Pryor was cross-examining Detective Ray Hermosillo. He was standing significantly taller during that moment.
Interesting.
John Pryor's cross-exam, I just have one thing to say. I have more than one thing to say, but this is the thing I'm going to say right now. First off, Tammy Daybell's little response to the paintball gun incident was neither a text nor an email. It was a Facebook post that she posted about somebody coming to her with a paintball gun, pointed it at her and trying to shoot her with it. This is what I've always said about her 911 call. First off, she called 911. I was very upset how things just ended just now with John Pryor saying to Detective Ray Hermosillo, so really this 911 call incident, she called about a paintball gun incident, right? Thank you, Time Lady. And Ray Hermosillo calmly said, yes, that's
All rise, please.
They're back in court. And I have to say, I agree with her about that. The way cross-examination ended with Pryor trying to throw shade at Tammy and calling in 911 about a paintball incident, calling it a paintball incident, and then trying to pick apart whether
Jury present and counsel.
Thank
paintball.
you. Please be seated.
Yeah, only the cult members say positive things about Chuck.
All right, we are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. The defense is conducting cross-examination of the witness, Detective Hermosillo. Mr. Pryor, if you'd like to continue, you may.
Officer Hermosillo, I'm going to take my time. I didn't probably need too much coffee this morning, so I waited that over the lunch hour. Now I think I'm okay. Let's hope so. And I think the judges admonished me enough at this point that I think I got the point. So we're going to go a little slower if you don't mind.
Lower.
So I want to go back to the paintball incident. And you said that one of the pieces of evidence was that Alex Cox had Googled a black Dodge Dakota, correct?
He Googled what caliber it would take to shoot through the windshield of Dodge Dakota.
Was it the windshield?
Yes, I believe so.
Okay. Judge, there's previously been an admission of Exhibit 34 by stipulation. That's Homer J. Maximus with a reference from the state as well. And we'll get back to that in a minute. But there was at least a reference at some point that there was going to be trying to find out what kind of caliber it would take to penetrate a Dodge Dakota vehicle, some windshields or otherwise, correct?
Correct.
And you took that as a threat, as a means of saying that's why Alex Cox was trying to kill Tammy Daybell.
That Google search, along with him being at that residence that same day earlier,
Okay.
and the incident involving Tammy Daybell.
Okay. 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 And that's what drew you to that conclusion. Is that correct?
That's correct.
Okay. So we don't know who was driving the Dodge Dakota regularly, do we? Because you didn't speak with the kids. Is that right?
That's correct.
Okay. And we do know that on the day that you said Chad Daybell, at least you were alleging that Chad Daybell fled on sometime in June 9th. Is that right?
Objection mistakes the testimony.
Well, try to clarify that. High rate of speed, Chad Daybell left the area. Is that fair?
That's fair.
That's what you're stating, correct?
That's correct.
And in the vehicle that he was in, do you know that that was the Dodge Dakota that supposedly he was fleeing in?
It was not Dodge Dakota he was fleeing in.
Okay, what vehicle was he fleeing in?
I can't recall off the top of my head. We have it in impound, but it wasn't the Dodge Dakota.
Okay. Okay. So there were two vehicles, an Equinox and a Dodge Dakota. Which one was it?
Which day, sir?
On June 9th, which, there are two vehicles that the Daybell's owned, the Equinox and the Dodge Dakota. Which one was it that he was allegedly fleeing?
I just stated I couldn't recall the vehicle that was arrested.
Okay, that's fair, that's fair. So, just to recap, we know that there was a Google search by Alex Cox on his Homer J. Maximus account, correct? Correct. And that there was an allegation that Alex Cox was trying to figure out what type of caliber to at least shoot at a black Dodge Dakota, correct? Correct. Okay. We don't know who the target was, or who the target was in that Dodge Dakota, but we know it was someone who owned the vehicle, obviously, right?
Well, I would assume so.
Okay, okay. Now, that's what you based on the fact that you thought that there was an attempt on Tammy Daybell that day, correct?
Correct.
Okay. Now, when you read that email from the Homer J, or the research from the Homer J. Maximus account, did you take into consideration the date of when that search took place?
I did.
And when was that?
I can't recall. I have to refer to my notes.
Okay. I'm gonna take the liberty of helping you out a little bit.
They actually did get that money. They actually did get that money, that $400K. That's why they went off to Hawaii. But after that, assets were frozen. That's my understanding. And my understanding is now Pryor owns his house as payment for the legal fees.
At least I think that would help you. There. Judge, I don't know why it's not going up on the screen.
Is this a exhibit? 34, sorry, which 34 has sub exhibits?
I believe it's A, Judge.
34A is admitted previously by stipulation. 34A is what you're trying to publish, Mr. Clark.
Yes, Judge.
I don't know if there's one can assist to see it, but okay, it is admitted.
There we go. I'm sorry, and I don't know what. All the best laid plans to prepare for this. So I'd like you to take a look up at the screen, if you would. Look at the date of when this search took place.
Okay.
So if I understand, the incident with the paintball gun took place 3 days before this search took place.
Correct.
Okay, but you still continue to believe that was the basis for someone going after Tammy Daybell, is that right?
That's correct.
Okay, all right. But you don't have any Google searches that suggest anything else in a threatening manner. This is the one and only that you're relying on, is that right?
No, that's not right.
All right, what else are you relying on?
If you scroll up on October 9th, I believe that evening,
Okay. Go ahead.
Alex Cox Googles how to make an AR-15 function in cold weather.
Okay.
There's some other Googles if you'd like to pull it up.
Well, I've got those and we're gonna go through those. and we'll have an opportunity to do that, but,
And that was the night Tammy was shot at.
okay. And he Googled that night, right?
That's correct.
What time of night was that, do you recall?
I'd have to look at my notes.
Okay. Okay, but he also had a habit of Googling a lot of things, right?
I can't answer that.
Well, you know about the Hannibal Lecter thing, right?
No, sir.
Oh, okay. Well, before we get to the Hannibal Lecter thing, let's talk a little bit about some of the other searches from Homer J. Maximus. October 21. Best tactical cutting, right?
Correct.
See that one?
All right, and Mr. Pryor, you are gonna have to stay by that microphone or we don't pick up what you said.
Good judge.
Yeah, I had heard that too, Tiggy Girl, and that makes sense.
October 22nd, 2019. Sharpening swords. Knife sharpener, right?
Correct.
Okay, what was the date of Tammy Daybell's death?
October 19th, 2019.
Okay, so 3 days after Tammy Daybell dies, Alex Cox is still looking at sharpening swords and a block knife sharpener 3 days after Tammy Daybell's death. Is that right?
Correct.
Okay.
Yeah, we should maybe nickname him John
October 23rd.
John Reach Pryor. That's what he's always doing, is reaching.
4 days after Tammy Daybell's died. 15 facts about the silence of the lambs you didn't know. Call that one?
No, sir.
Okay. And that was 4 days after Tammy dies, right?
That's correct.
Okay. Now, when you searched, and I believe it was 107, was that the unit that we found all of the knives and the guns?
No, sir, that was 175.
Okay, 175, that was Lori Vallow's unit then, right?
That was the unit that Lori Vallow lived in, but Alex Cox was on the tenant agreement.
Okay, okay. And your testimony previously, I believe that was a day or so ago, there were a significant number of weapons found, right?
That's correct.
Did you do a check on all of those weapons to see who they belonged to?
I personally did not do a check on all those weapons.
What about the knives or the ammunition? Did you check and see who those belong to?
I'm not quite sure how to check on who the knives belong to.
I don't either. I just asked because are you presuming that the owner of those knives and guns and ammunition is Alex Cox?
They were found amongst his belongings, so I presume that is.
And we talked about this before, when I was doing some voir dire and native objection, that a lot of those items were items, the knives and the ammunition were items that you pulled out of bags and displayed for purposes of, for lack of a better word, staging them for your photo op, right?
That's correct.
Okay, okay. But again, all of the ammunition, all of the weapons, all of the knives, and the ski mask, that was found in Alex Cox's, at or near Alex Cox's belongings, right?
Correct.
So I don't want you to speculate, but you're presuming that Alex Cox owned all of those, right?
That's correct.
There's no indication that Lori Vallow had several guns and knives and things like that. Is that fair?
That's fair.
Okay. I want to switch gears a little bit.
G after like 2 hours.
And I want to talk to you a little bit about Charles Mallow. Okay? Okay. And I assume you've been communicating with the folks down in Arizona about all of that. Is that fair?
Yes.
Okay, so you're well versed in the facts as it relates to Charles Mallow, correct?
No, I wouldn't say well versed. I know the basics.
Okay, but are part of the basics to know where the court proceedings are and who was charged with what?
You would have to be more specific.
Okay, and do you know currently who's charged in the death of Charles Mallow?
Yes.
Okay, who is that?
Lori Mello.
Okay, are you aware that the prosecuting attorney down in Maricopa County issued a
Objection hearsay.
That's the same.
Judge, I'm asking whether he's aware, not whether he.
Well, by the time you say what he's aware of, that all the information's coming through his, so it's the same.
Okay. Are you aware that Chad Daybell is not charged with anything in Maricopa County relating to Charles Mallow?
Yes, I am.
Okay. Brandon Boudreaux's next. Who's been charged in the allegations against Brandon Boudreaux?
Lori Mello.
Is there anybody else?
Not that I'm aware of.
Okay, and you're also aware that Chad Daybell has not been charged in the allegations as they relate to Brandon Boudreaux, is that right?
That's right.
Okay, now if Alex Cox was still alive, the suggestion seems to be that he would have been charged with both of those offenses. Would that be fair?
Objection calls for speculation.
Sustained.
Okay. Do you have any information as to who killed Charles Mallow?
Yes.
Who do you believe killed Charles Mallow?
Alex Cox.
Okay. Who do you believe took the shot at Brandon Boudreaux?
Alex Cox.
Okay, thank you. Now, did you have the occasion to look into the history of Alex Cox a little bit?
Briefly.
Okay, were you aware of an incident that occurred in, let me get the date right, August 5th of 2007?
You'd have to be more specific about what occurred on that date, sir.
On that date, there was an allegation that there was an assault on a Joseph Ryan.
That's correct.
You're familiar with that, is that right?
Yes.
And in 2007, is there any indication that Chad Daybell knew Lori Vallow in 2007?
Not to my knowledge, no.
Okay. And in that incident, are you aware that Alex Cox committed aggravated assault on Joseph Ryan?
Your Honor, at this point, I'm going to object to relevance.
I think we're outside the scope of what's happening in this case, Mr. Pryor.
Judge, can I approach, please? Counsel.
Sure, outside watching.
One of my pet peeves with lawyers is when they take on a really mocking tone. And that's what Pryor does. And he just did that. So he just asked a question, Hermosillo answers, and he says, okay. I cannot stand that. The defense lawyer in the Apple River stabbing trial was incredibly annoying in terms of that pet peeve. He was super condescending. And hold on one moment. So when he was cross-examining witnesses, especially if they would say a few times in a row, he would ask them a question and he would say that, and they would say, I don't recall. So then he would start to enunciate his words more in a more specific way. So he would say, do you remember? Do you remember? And it was like he was mocking them, as if he's saying, I know you remember. You're just saying you don't remember. Do you remember? Do you remember? It was so freaking annoying. And it would piss me off too, or put me off too as a juror, Tiggy girl. I'd be like, hey, so in that particular trial, the witnesses he was doing that to were people who had been brutally stabbed by his client. And that client that had brutally stabbed them, that had literally stuck a knife in their gut and like ripped their guts out. This defense attorney is sitting there mocking them and denying whether the, like, minimizing their experience and calling into question their memory or lack thereof, calling into question their level of trauma. It was really infuriating. It was hard to watch. Do you remember?
Judge, all right, but I just wanted to reiterate, we had an objection that was sustained on relevance grounds, and the court confirms that objection, including under 403, it's not relevant for purposes of this case.
Judge, based on that ruling, the state would move to strike the question.
All right, the question is stricken, that topic won't be allowed.
I would like to talk to you a little bit about Chad Daybell's phone, and I'd like you to refresh my recollection. Okay? Yeah. You made mention that on the 26th, when you were doing the initial welfare check, you followed up with calls to Mr. Daybell. Is that right?
That's right.
And your testimony was that you weren't able to get an answer, or the phone was turned off?
Every time we called, it went straight to voicemail, I believe.
Oh, all right. Did you have an opportunity to go through Mr. Daybell's phone records?
I personally have not, no.
So there's no indication that the phone was ever turned off, was there?
I can't testify to that. I didn't go through these records. Correct.
But you can testify that it just went to voicemail.
Correct. I can testify he didn't answer.
Okay. Now, when you searched Lori Vallow's residence, there weren't any clothes in there. In the residence that she had hanging up on hangers, right?
That's correct.
Do you have any information to suggest that she had mailed or shipped her clothes to another location?
No, I don't.
Okay. And then you, at the time you were aware that Mr. Daybell obviously was married to Ms. Vallow at that point. Is that correct?
That's correct.
And is it your allegation that Mr. Daybell left on the 26th or 27th and also tried to avoid contact with law enforcement?
I can't answer why Mr. Daybell left. All I can answer to is I wasn't able to get a hold of him after that date.
Okay, and after that date, did you happen to check credit cards or phone records or anything like that to try to locate him?
Again, sir, I didn't go through Mr. Daybell's phone records.
Okay. Did you gain any information that Mr. Daybell was going on a vacation around the 26th or 27th of that, the end of the month?
We later learned that Mr. Daybell was in California.
Okay, and later learned that he was in California, and that was about the time of the 28th or 29th of November, is that right?
I'd have to refer to my notes.
Okay, and were you aware?
Sounds right.
Okay. And again, maybe the coffee's still affecting me, I'll try to slow down, okay?
Stacy.
But you're also aware that Mr. Daybell on the 28th being at Knott's Berry Farms, right?
Correct.
And that was a family vacation with his kids, correct?
I can't testify to who was there.
Okay, so Mr. Daybell wasn't fleeing. He was on the 26th or 27th month when Lori Vallow's closet was empty. Mr. Daybell was on a family vacation.
I can't testify that he wasn't fleeing. I can testify that I knew he was in California at a later date.
Okay. And you know that later date was the end of November, right?
Close to that date, sir, yes.
Okay. And you know that subsequent to that, he went on a trip to Hawaii after that, right?
Yes, he was in Hawaii after that.
Right. So if I understand the testimony, Mr. Daybell was at some point after the 26th, went on a planned family vacation at Knott's Berry Farms, right?
I can't testify it was a planned family vacation.
Okay, all right, that's okay. And then subsequent to that, he then went to Hawaii on a trip to Hawaii, where there was some contact with you folks, correct?
Yeah, we made contact with Mr. Daybell in Hawaii.
Okay. And how is it that you found it out that he was in Hawaii again? Remind me, please.
Through tips that came in through our hotlines that we had set up and cell phone data.
And this is just a question, I'm kind of curious. Did maybe you just look at plane records?
Are you asking?
Yeah, I'm asking, did you guys look at?
I can't.
Oh, I'm sorry. Almost didn't slow down. Go ahead, I'm sorry, sir.
Can you repeat the question, please?
Did at any time, did you just take the initiative to look at plane records?
So each officer was tasked with different things.
Okay.
We did have an officer that looked through financial, and I assume he did look through plane records and credit cards.
Okay. And if Mr. Daybell was flying on a commercial plane or traveling from Boise to Knott's Berry Farm on a commercial plane, in your experience and knowledge of these things, there would have been a record of that, right?
That's correct.
Okay, all right, thank you.
Thank you.
Now, I'm going to switch gears again a little bit, okay? Please forgive me because I just want to make sure I hit all of these subjects. And before we go there, I want to make sure you did get a subpoena from my office. Is that correct?
That's correct.
And you've acknowledged that you've accepted that, correct?
Right.
And you were kind enough to contact my office and agree that if I need you to come back, you'll come back in a time that's suitable for both of us. Is that fair?
Yes.
Was there anything else discussed during that phone conversation?
Dates that I couldn't get back.
Okay, and that was because, and we're not going to get into this to let everybody know, because it's nobody else's business, but you have an obligation of some sort, and I've acknowledged that, and we're going to work on that. Is that fair?
Objection elements? Sustained.
Okay. Now, as part of your investigation, and I want to be specific to JJ Vallow, okay? The last known sign of life was the 22nd. Is that fair?
The last
time that someone known.
It was September 22nd of 2019.
Right, okay. And the last, at least proof of life for Tylee Ryan was September 8th.
Of 2019.
So I'll do the math in my head if I can. There's 15 days difference between Tylee Ryan and JJ Vallow. Is that correct? For the last proof of living or life, respectively.
Roughly
15 days. You think JJ died on around the 9th of September, 8th or 9th of September, and Tylee was the 22nd or 23rd. Is that fair?
That's correct.
Okay, thank you.
That was some great journalism.
Now, as part of the investigation, you looked into where JJ Vallow was on the 22nd of September, correct?
Correct.
And on the evening of the 22nd of September, he was at Lori Vallow's home.
That's correct.
Okay. And present in that home, staying in that home, were Lori Vallow, correct?
Correct.
At least on the 22nd, JJ Vallow was there, correct?
That's correct.
Melanie Gibb was there, correct?
Correct.
And David Warwick was there.
Correct.
Okay. And on that evening, they were conducting some sort of a religious podcast, the three of them, correct?
Yes, sir.
And the allegation is that JJ was acting up and went into the care of Alex Cox.
Correct.
And then Alex took JJ into a separate apartment, correct?
On which day?
On the 22nd?
He took him to apartment 107, correct?
Right, his apartment or whoever was on the lease for that apartment, right?
That's right.
Okay. And then the last time that anybody saw JJ was later that evening, is that fair?
Yes,
And that was when Alex Cox was carrying JJ Vallow into the apartment of Lori, David, and Melanie Gibb, right?
correct.
We were all staying there together, correct?
That's correct.
And then somewhere at that point, whether it was at that point or subsequent to that evening, or that evening, that's when you believe that JJ Vallow was murdered.
That's correct.
Okay. But the next morning, there were 3 people in the apartment at that time early in the morning, correct?
Objection foundation.
Well, do you know who was in the apartment early that morning on the 23rd?
Hold on, prior, there's an objection, I think that would go on, sustained.
Do you have any knowledge of who was in the apartment on the 23rd of September, the morning of that morning of 2019?
Yes,
And who was there?
David Warwick, Melanie Gibb, and Lori Vallow.
Okay, and at that point, you believe that JJ Vallow was already dead?
I can't testify to the time, but I believe he was killed.
Okay, but then within 2 hours later from that morning, you believe that he was buried on Chad Daybell's property, is that right?
That's correct.
Okay, okay. You had an occasion to talk with Melanie Gibb and David Warwick, is that right?
That's right.
Now, you did it a couple of times, if I recall, one by phone, right? With Melanie Gibb?
Correct.
And that wasn't recorded, was it?
It was recorded.
It was recorded?
With her attorney?
No. No, I'm talking about a regular phone call with Melanie Gibb, without an attorney.
I don't remember a phone call.
Okay, all right, we're gonna revisit that maybe at another date, but that's fine. But you also went down to Provo, Utah. And I'm going off of memory, but it was Provo, Utah on the 4th of June of 2020, is that right?
Sure.
Now, at that point, you were interviewing both David Warwick and Melanie Gibb about information they had about these allegations, correct?
Correct.
Okay. And who else was there?
Myself, Lieutenant Ball, and Prosecutor Wood.
Okay, so the prosecuting attorney, Mr. Wood, right there. And a lieutenant that you work with and yourself drove down to Provo, Utah.
Correct.
And was there anybody from any local law enforcement there as well?
No.
Okay, now there was an effort to record that conversation, is that right?
Yes, it was recorded.
Okay, was the entire thing recorded?
I believe the very beginning wasn't. The recorder malfunctioned or something happened that was recorded, but the majority of that interview was recorded.
The majority of it was recorded.
That's correct.
So if I represent to you that there was 22 minutes of recording on that interview, does that sound about the length of what the interview was with Melanie Gibb?
No.
It doesn't?
No.
Okay. Would it be helpful if you were able to listen to that recording and view that recording to refresh your recollection?
Refresh my recollection.
About the length of time that recording was?
It should have been longer than 22 minutes. I'll be there longer than 22 minutes.
How long were you there?
Roughly, say about an hour maybe.
Okay. Now, your testimony is that it should have been longer than 21 or 22 minutes, is that right?
That's correct.
Would it surprise you to learn that, well, you don't know exactly how long that interview took place, right?
Yeah, I couldn't tell you the exact time.
And you don't know the length of the recording itself, is that fair?
That's fair.
Okay, and in order to determine that, it would be helpful for you to refresh your recollection by listening to the interview, and it would be able to answer those questions for you. Is that fair?
That's fair.
Your Honor, I'm going to object beyond the scope.
We're way beyond the scope of your red counsel. If also the officer's going to review that, and I permit it, of course, it's not going to be in the presence of the jury. So also saying the objection on beyond scope.
Judge, are you talking about beyond the scope of direct examination?
Yes.
Okay, then officer, we'll revisit that at another time, okay? And we'll leave that for another opportunity. When I call you back. Now, on the day that JJ Vallow
Sucks that this
was found on
detective
June
has to
9th,
come
on June
back.
9th. Okay? The pictures and the testimony you showed suggested that he was wearing red pajamas and some Skechers socks. Is that right?
Sure.
Okay, do you have a recollection of what JJ Vallow was wearing based on your investigation when he was carried by Alex Cox from Alex Cox's apartment to the upstairs of Lori Vallow's apartment?
Objection, this calls for hearsay.
It doesn't necessarily call for hearsays, wondering what he observed him wearing, so.
Yes.
Let's not roll on that.
Tell me if you know the answer.
I don't know the answer to that question.
Okay. Do you know whether or not JJ Vallow was wearing red pajamas when he was carried upstairs by Alex Cox?
Sir, I don't know the answer to that question.
Okay. And Judge, I think at this point, I'm going to save the rest of my questioning for when I call the officer back in my case in chief. That's okay.
Very well. You can do that. I'll conclude the cross-examination then. This time we'll begin with redirect from the state.
Thank God. Yeah, I think that's why he's stopping his questioning, because he's keeps wanting to go well out of scope. So he's planning to call this witness back, which sucks for this detective.
Your Honor, may I be handed States Exhibit 31? Yes, and States Exhibit 30.
Oh, hey, if you haven't hit that thumbs up, can you please remember to do that? Thank you very much. My poor little channel hasn't been in the algorithm for a bit, so it needs some reminding.
Detective, you testified earlier about when you first met Alec or Chad Daybell.
Correct.
Who was he with?
Alex Cox.
Did he look afraid of Alex Cox?
No.
Okay. Alex Cox was Chad Daybell's brother-in-law, correct? When you met him?
That's correct.
Thank you, Jamie Lee. Looks like he's starting to get lower.
Detective, you were asked about your beliefs. Is that fair? In cross-examination, you were asked about your beliefs?
Yes.
Let's talk about your investigation. When you started your investigation, what was the scope of your investigation?
I know.
Initially, it was to find
crazy.
The Jeep from Gilbert, Arizona.
And then it expanded, correct?
Correct.
And then what was the scope of your investigation?
To find the whereabouts of JJ and Tylee.
And all this time you're collecting information from various sources.
That's correct.
Your Honor, may I publish State's Exhibit 31.
Yes.
Detective, you were asked about your beliefs, correct?
That's correct.
And you were asked about your beliefs regarding, I'm gonna call it the paintball incident, is that fair?
Yes.
And when I'm talking about that, to your understanding, what am I referring to?
To attempted shooting of Timmy Daybell.
And you testified you don't believe it was a paintball gun.
That's correct.
So why not?
Through our investigation, we learned that Alex Cox was in the area and on the property of Chad Daybell the morning that Tammy Daybell was shot at October 9th. Through Google searches from Homer J. Maximus, which was Alex's Google account, the night that Tammy Daybell was shot, it was a colder evening. And the Google searches were how to make an AR-15 function in cold weather. And without referring to my notes, can I refer to my notes?
Would it refresh your memory to review your notes?
Yes, sir.
Your Honor, may the witness look at his report.
No objection. Yes, you can look at it, not to testify from, to refresh your recollections, so once you looked at that, it's now.
Walk away, Renee. It's the same prosecution team, although Rob Wood is taking the lead in this case, and I think it was a different prosecutor who took the lead in the last case, but it's the same team. In my view, I think, Rob Wood is a very solid and experienced prosecutor, and he's doing a fine job. The other prosecutor was more emotionally connected, a little bit more well-spoken. No, she didn't die from being shot at. But there was an assassination attempt on her life 10 days before she died.
On October 8th, the night before we believe Tammy was shot at, Alex is Googling drop yardage from 300 yards to 100 yards, which we assumed when you're shooting a rifle, you're adjusting your sights to your target. That was the night before. The morning of the shooting, Alex was on Mr. Daybell's property. We have him driving up and down the road of Mr. Daybell's property and also on the property. Later that evening into the early morning hours of October 10th is when he Googled how to make your AR-15 function in cold weather. So that's why we believe that it wasn't just a paintball gun. We believe that Alex Cox was there to shoot Tammy Daybell.
Yeah, it doesn't say shooting a paintball gun in cold weather.
I'm going to have you look at this timeline. As far as you're aware, these dates are accurate, correct?
I'm sorry.
As far as you're aware, these, in pursuant to your investigation, these dates are accurate, correct?
That's correct.
Did the fact that Tammy Daybell died 10 days after that incident have any bearing on whether or not you believed it was a paintball gun?
Yes.
Did the fact that Chad Daybell got married 17 days later have any bearing on your belief whether or not it was a paintball gun?
Yes,
The fact that there were 2 children buried on Chad Daybell's property have any bearing on whether or not you believed it was a paintball gun?
yes,
Did the fact that Lori Vallow's husband died within months of these other deaths have any bearing on your belief of whether or not it was a paintball gun?
absolutely.
And finally, did the fact that Brandon Boudreaux was shot at on October 2nd, 2019 have any bearing on your belief of whether or not it was a paintball gun?
Yes,
And it's your belief that Alex Cox was tied to these events, correct?
that's correct.
And because you were asked about your beliefs, was it your belief that Chad Daybell was tied to these events?
Yes.
Why?
Based on our investigation, the lies that we've been told, the fact that we tried to get a hold of the kids' mother, Lori Vallow, kid's stepfather, Chad Daybell, their uncle, Alex Cox. We weren't able to get a hold of anybody. We were left in the dark. Based on all those events, that's what our beliefs were as collectively.
I know, it's just crazy. Walk away.
Pursuant to your investigation, you know when Alex Cox died?
December 12th, 2019.
At any time after Alex Cox died, did Mr. Daybell call the Rexburg police to report that there might be dead children located on his property?
No, he didn't.
Did he call the Rexburg police with any concerns that perhaps his wife had been harmed by someone?
No, he didn't.
Did he call the Rexburg police before Alex Cox died to say he might be in danger?
Judge, we're going beyond the scope, but walk into a desk, there'll be an opportunity to revisit those issues.
I'm gonna sustain that objection.
Okay.
Next order.
Again, so the first time you met Chad Daybell, what was the first thing you asked him? When you had an opportunity to speak with him?
Has to answer.
This is a response to the cross your overruled.
I asked him when the last time he saw JJ Vallow was.
And when did he answer?
In October, in apartment 107 with Lori Vallow.
And did you ask for Lori Vallow's phone number?
I did.
And what was his first response?
Judge, this has been asked to answer.
This is a response to the cross.
Overall, his response was he didn't know her cell phone.
He didn't know his wife's cell phone number.
Detective, you were asked a little bit about how you do an investigation. Correct?
He seemed
And
to be slapped.
we spoke about the scope of your investigation in this case.
Correct.
So it's your testimony that you followed where the evidence took you in this case.
That's correct.
No further questions, Your Honor.
All right, Mr. Wood.
Judge, there were some issues that were opened up. I'd like the opportunity to revisit this.
There were a few, so I'll allow a limited recross, particularly considering your statement, you're gonna recall the witness, so it'll be limited, but if you'd like to, Mr. Pryor, you may.
Detective, there was some testimony about, I'll wait for you to hear.
Thank you.
There was some testimony that you had the whereabouts of Alex Cox on the property of Chad Daybell, and that would have been on the 9th
That's correct.
of October.
Yes,
Do you have a recollection of how long he was there on that property?
I don't.
Okay, and you're basing that knowledge on his phone records and his pings, right?
Correct.
Did you have an occasion to look at all of Alex Cox's whereabouts on that day? By way of his phone records, or did you just look at that specific time?
We were more interested in that specific time.
Okay, and I gather from your testimony that you didn't look at between 8 and 10 o'clock on the 9th when the paintball incident took place. You didn't look at that time for Alex Cox's whereabouts, did you?
If I remember right, I didn't get his location near the property at that time. There was no location.
Okay. And isn't it true, officer, that you didn't get his location at that time because Alex Cox's phone was pinging in Idaho Falls at that time, several miles away?
I can't testify to that.
Okay. But you know he wasn't on the property by way of all of the metadata. That's the word you used, right? Metadata?
Correct.
By the metadata, Alex Cox wasn't on the Daybell property when Tammy Daybell was shot at with a paintball gun, correct?
No, sir, I can't answer that. I can answer that Alex Cox's cell phone or his device was not on the property.
Okay, and you can also say that his device was on Chad Daybell's property sometime in the morning of the 9th of October, right?
And driving down the roadway in front of the property.
Right. And we don't know who else was on the property on the 9th of October, do we?
I can't testify to who was on the property.
Right. So we don't know if he was there by himself or is he there with other folks, correct?
That's correct.
Okay. And when we're talking about you've been on the Daybell property, right? A couple of times.
Yes.
And you took a photo of the car, and we're going to revisit that next time we get together. But it's not 100 yards from the end of the Daybell driveway to the road, is it?
No, sir.
Do you have an idea of how long that driveway is? Could you give me an idea if you know?
I couldn't testify to that.
Is it 50 yards?
No, I would say maybe 30, maybe
30 yards?
20, 30 yards. Yeah.
So 60 to 90 feet.
That's my rough guess, yes.
Okay, so if we're looking at a rifle at 300 yards and dropping it down to 100 yards, we don't need 100 yards to get from one end of the Daybell driveway to the other, do we?
What our investigation or our belief was, if you're asking me what my belief is.
No, I'm asking you the distance down the end of the Daybell driveway to the top of the Daybell driveway. That's not 100 yards, right?
Well, that's correct.
That's all I have, Judge. Thank you.
Mr. Wood, is the state ready to call tonight's witness?
Your Honor, committee approach.
Yeah.
Your Honor, may this witness need to stand?
Oh, I didn't know we are. You want to sidebar first?
No, we're done.
Okay, well, Lieutenant Garcia, you may go ahead and return down. And because you are still under subpoena, maybe recall, I will admonish you to abide by the court's exclusionary rule. You're not permitted to review testimony trial between now and the time you return testimony. If you fail to follow that and follow the trial or observe any testimony, you will not be permitted to testify again. All right. Okay, thank you.
Well, Detective Hermosillo is finally off the stand. Thank goodness for him. So who is next? It might be interesting to maybe for each witness that testifies for us as a group to judge who won that witness, who did better with that witness. So who do you think did better with that witness in terms of facts and evidence and questioning. And I personally feel that the prosecution did better, not because they got any zingers in on the defense, but just that it was more factual. It was more factual. It wasn't nitpicky. Honestly, my choices by virtue of the fact that John Pryor seemed to just go in about a gazillion directions, well out of scope. Yes, the prosecution was very well prepared, is very well prepared. And that is what I do appreciate about most of these cases that I stream here, is that most of the time, not every time, but most of the time, the state seems very well prepared. And you get the entire gamut in terms of whether the defense is prepared. There's some amazing defense attorneys, and then there's some really awful ones. And then, of course, you get the pro se litigants, right? And yeah, I agree, walk away. Pryor is asking purposely confusing or convoluted questions. And after a while, especially in a long trial, that starts grating on a jury. It really starts to grate on the jury, and they see, some of them can see through the fact that it's probably intentional. And also when he starts to get hostile and demeaning and condescending, and nobody likes to be treated like that. Nobody likes to see other people get treated like that, especially when it's unwarranted. It's not like Detective Hermosillo was doing anything to warrant being talked down to. And at certain points, it seemed like Pryor, was trying to allege that there was police misconduct, and he was trying to go in that direction. And unless I'm missing anything, this is one of those cases where I really haven't seen any evidence or complaints or major complaints about police misconduct. I have personally complained about lack of action by the police in Arizona with regard to Charles Vallow, because I feel like if they had taken better notice of what Charles Vallow was saying in Arizona in January of 2019, a lot of this stuff wouldn't have happened. He tried to have Lori committed, and they basically took her side on it. The Hannah defense. That Hannah defense, if I remember correctly, oh yes, the jury is 10 men and 10 women. So it's 12 jurors, 8 alternates, and out of that those 20 people, 8 jurors, 12 jurors, 8 alternates, it's 10 men and 10 women. And interestingly for Lori's trial, it was also 10 men and 10 women, and it started 1 year ago to the day that this trial started. And it's not like they really plan those things, You can't really plan a trial to start on an exact particular day, really. And yeah, that's right. The police in Arizona took Lori's side because she was purdy and manipulative. I mean, that's just all there is to it. And she had Tylee and Melanie with her in the police station, and they helped her. Both of them did. I'm trying to think back, Stacy, on the defense in Hannah's case. Oh, Hannah Gutierrez. Yes, I think you mean Hannah Gutierrez with the Rust trial. That was a good defense. He was a good defense. Jason Bowles, I think his name was. He wasn't too annoying. He could be annoying sometimes a little bit because I think he played dumb more than he really was, but he also had kind of an approachable energy about him. You know, he didn't come across too aggressive or condescending. So Chad is starting to slump a little more, it looks like. Let's zero in on him. It's not a very good picture though, but it's very, very difficult. I think I might be circling Lauren Mathias right there.
All right, counsel, if you'll give me a moment, I want to clarify our record on exhibits admitted through that last witness and make sure the court has a clear record of what came in as it relates to exhibit 34. So we did have a stipulation that on the record here, and for the jurors to know as well, we had, I believe 34 had separate attachments or would be separate exhibits, 34A, B, C, D, and E. Is that what 34 consists of?
Yes, Judge, and state is stipulated to the admission of all of 34, which included those separate exhibits. They've already been stipulated.
Okay, and understanding they were stipulated to, but still on the record, I'm going to make clear that exhibits 34A, 34B, 34C, 34D, and 34E have all been admitted into the record and are evidence in the case. Does the state concur with that?
That sounds accurate, Your Honor.
Okay. Counsel, when we conclude, I'll have you stick around for a minute to also see if we need to further clarify exhibits on the record. At this time, ladies and gentlemen of the jury and those in attendance, I've discussed scheduling here with counsel. We got this trial started and moving along with jury selection a little quicker than anticipated, and the state is at its stage of putting on its case in chief. They're doing their best to line up witnesses to appear here, coming a little sooner than anticipated. And that's the explanation. We are going to go ahead and conclude for today in order to allow the state to have a full day's worth of evidence and testimony beginning on Monday. And then next week, we should be on a full slate of Monday through Friday trial. Notice also, as I mentioned previously, that tomorrow is not going to be a day of trial. So as I understand it, the state would request that we then conclude trial for the week and commence again on Monday morning. Is that correct?
Yes, Your Honor.
The state, does defense have any objection to that?
No objection, Judge. Thank you.
Okay. So before you leave then, ladies and gentlemen of the jury, this is a pretty long break in between evidence now that you are sworn jurors in the case. And I will again admonish you to please do everything you can to not do anything to learn about the case, investigate the case, look the case up, follow any media in the case. If you do see anything being reported, try to avoid that. Don't talk about the case to anyone else or any of the evidence or facts with anyone, including with each other. You can only do that when you start your deliberations. And when you return on Monday morning, when we'll commence at 8:30 with more evidence, I will be asking the jurors as they return to complete those admonitions and certify under penalty of perjury that you have followed that instruction. So I appreciate you doing that so far. I have confidence you will continue to do that. And thank you for your time and efforts today. That will conclude our trial for today, and we will resume again on Monday with further evidence.
All rise, please.
All right, everyone. So we will not be back in court until Monday morning. I might still go live later today or tomorrow to talk about some other cases. But in terms of recapping for today, poor Detective Hermosillo was on the stand all day with continued questions from defense or from the state and then from the defense and then going back and forth. And you know, obviously Pryor tried to go well outside his scope, and then, you know, he said, oh, I'll call him back as a witness. And I think maybe the judge said, rather than calling him back as a witness, just ask him your questions now. And so he asked him his questions now. And based on Pryor's questions, Pryor is really heavily going toward pushing the agenda of it's all Alex and Lori working together, and they're really going to probably explore the relationship between Lori and Alex, which by all accounts was incredibly inappropriate. I would love to know what Chad thinks about the claptrap Lori spewed at her trial. Oh my, he probably thinks it was great. He probably thinks it was great. It's exactly the stuff that made him fall in love with her. That's my thing. You know, Stacy, I want to believe that jurors take their duty very seriously and they don't look at the news. I'm one of those people that really wants to believe the best about everybody. I like giving people the benefit of the doubt. I've been sorely disappointed since my time on YouTube. How many times I've given people the benefit of the doubt only to be incredibly disappointed about what really happens. But in my day-to-day life, I'm relatively old. Retirement age for sure, or close to it. I worked in business for a long time. All the people I came across, they wanted to do their jobs seriously. They wanted to do right by the people they worked with and for. And I don't know anybody that would want to cheat a jury or cheat a case out of its rightful conclusion. Yeah, my insides haunt me if I lie. And I see people here on YouTube who can lie as if it tastes good coming out of their mouth. And for me, I can't live with lying. I literally can't. I can't live with lying. So I don't know. I guess that makes me a radically different person than a lot of people. I don't know. But it certainly has been a quite a eye-opening experience here on YouTube. Makes you really question I don't know, just makes you question a lot. But anyway, you are all the first to know that I'm about to schedule a live stream for my other channel, Checkmate Humanity. Hello, Deline. Hello. Welcome back, Sparkle. Yeah, and that's true too, walk away. Emotionally mature, intellectual jurors could look at the news and still know that they need to keep that information out and that they are only supposed to look at the information from the trial and that they, but I'll tell you what, if I were a juror, if I were called to be a juror, knowing, hey, Lil Red, if I were a juror, knowing that I'm a true crime, enthusiast, maybe even a little bit of an expert because I've been following true crime for so long and I talk about it all day, every day, or, watch it all day, every day. I would actively avoid watching news about that case because I wouldn't want any of the bad or the misinformation to color my opinion without me knowing it, if that makes sense. I really wouldn't. I would worry that some of the wrong misinformation would creep into the back of my head and it would color my verdict. And so since I have that amount of care and respect and, dare I say, integrity about the way I think about these things, I like to give other people the benefit of the doubt that they do too. It's just been unfortunate to see actual evidence that there are so many other people who don't. So many other people in true crime who don't. So many successful people in true crime who don't. So speaking of that, you people in my chat are the first to know that I'm about to schedule a live stream. It'll be tomorrow afternoon, and I'm going to have a special guest on, Heels in the Air, and we are going to talk about, has Jonathan Lee Riches changed? Because I see a lot of people talking about Jonathan Lee Riches on a lot of different panels, and that guy has he's very interesting to me because he has gained a lot of traction on YouTube. And a lot of people say that that's because he's changed. He's different than he used to be. And I want to try to really explore the idea of, has he really changed? Or is he just more slick in the way he goes about? That's a good way to put it. Patricia Byrne, he's C-3PO with skin. So, Heels in the Air, from my end, from what I can see, has the most encyclopedic knowledge of JLR. She doesn't know him. She's certainly been targeted by him. She's been doxxed by him. I know what that's like. I think she's kind of in a similar position as I am with Rocket Man. That's the other announcement I'm going to make to you here. I now refer to Lana Oriani as a Rocket Man. Okay? Because I feel that I have proven that Lana was Rocket Man. And if you want to go look on my other channel and see that, so I get to call her Rocket Man, and there is a Rocket Man emoji. So walk away, Renee. Who are you asking? Who is this? Jonathan Lee Riches or Heels in the Air? So Jonathan Lee Riches is a true crime streamer who is infamous for vexatious litigation. He spent time in prison for fraud. Okay. And now has over 100,000 subscribers by going around covering and sensationalizing true crime cases. And he's gained a lot of support. Heels in the Air has been covering him. She makes she goes live, but she also makes videos covering not only Jonathan Lee Riches, but also Bullhorn Betty and other channels that she believes are tragedy pimps. And so it's kind of similar to the kind of coverage I do on my channel. Hers are more shorter clips and things. So I want to explore the idea, because every time any panel gets around to having a conversation about Jonathan Lee Riches and the coverage he's doing, they a theme that runs through it is, has he changed? Well, he's changed. No, he hasn't changed. So I want to look at the evidence of what it was like and what it is like now, and really look at, has he changed? And what is it that we're looking at? Changed from what to what? What is it that we're saying he was, and what is it that we're saying he is now? Right? So who else had access to private photos that were only sent to LO? And beyond that, who else is tacky enough to try to share those on a live? Yeah, there's no question in my mind. For me, it was the fact that not only did she have access to the porn that she put on the Rocket Man channel, she had access to the explicit images that she threatened to put out of her of the girlfriend before that. And Rocket Man is the one who came into a chat and said, Kim, you are next. Only Lana had the motive, the opportunity, the motive, the means, and the opportunity to target both the person that she revenge porned and the person she threatened. Boom. She's Rocket Man. So I call her Rocket Man. She is forever now more called Rocket Man. I will only call her by her real name or channel name when I'm doing a video about her, just for the sake of clarity. Yeah. Actually, if you want Walk Away Renee, you can do a Google search on him, and there is a Wikipedia page. He actually has some sort of record for filing vexatious litigation. He's not allowed to file any pro se litigation anymore because he is deemed a vexatious, like a federal vexatious litigant. It's something like 2,600 lawsuits. He sued. Some people in here will remember the crazy people he sued. He sued George W. Bush, I think. He sued the Dalai Lama. There's, I mean, some crazy ones. If you just, oh, here comes Patricia Burns with her limericks. There once was a woman called Lana who shouted 3 million words just to garner the attention and lust of a girl who was just trying to tell her she doesn't want her. Yeah, just look up Jonathan Lee Rich's, do a Google search, you'll find him. He's a lunatic. It takes a lot for the courts to cut you off. So he was jailed, actually imprisoned for identity theft. And then he came out and became this investigative journalist. This legitimate investigative on the ground, boots on the ground journalist who, by all accounts, doxes and trolls people, started out his internet career really, and social media career, just wanting to dox and stalk people. And early in his YouTube career, really what he would do is go and heckle people. He went to the Murdoch trial and stood in Buster Murdoch's face and said, "What happened to Stephen Smith? You killed Stephen Smith. You're mad." So that was like a year ago. That was a type of content he would do where he would just sit there and heckle and harass people. Now, when he does that live coverage, he isn't getting into people's faces and accusing them of murder, but he's still doing similar things. And the whole point of the type of coverage I do on my other channel is exploiting true crime cases to a point where the content for the content creator is putting their channel and their content above the victim and the family and exploiting it to the nth degree. And he does, in my view, he still does that, but he's doing it in a much slicker way. And in my view, Lana does that too. So it's just something, a way we're going to examine that on Saturday on my channel. And so watch for that to be scheduled. In the meantime, please remember to hit the like button. Thank you all for being here today and joining me for this live coverage of the Chad Daybell trial. I will see you back here for the Chad Daybell trial on Monday. And like I said, I may go live here again to discuss some other court action. Alrighty. Thank you again, and I will see you soon. Have a great rest of your day. Bye.